This is the second day in our hearing between in the arbitration between the Carlyle Group LP and others against the Kingdom of Morocco, exit case number arbitration 18/29. Good morning to all of you in the United States, and good afternoon to those in Europe. We have one development since yesterday, which I would like to share with you. And of course, if you have any other procedural issue, you will have now the opportunity to discuss them. The first point is that the United States has asked that to be authorized in accordance with the, I think it's 1019(2), but I may be wrong. I am not. Under Article 1019(2) of the FTA, then, and I quote, the non-disputing party may make oral and written submissions to the tribunal regarding the interpretation of this agreement. End of quote. They have asked to make an oral presentation of 15 minutes. And the tribunal, we have had the chance to deliberate, and we think that the best moment to do this would be tomorrow at the start of the session, so that both parties have the opportunity to make comments with regard to this statement from the United States, whatever it may be. And if this should not be sufficient, at the end of the hearing, we can discuss whether further written submissions with regard to the presentation by the United States, the statement by the United States, or with regard to any other issue are relevant, so that parties have the opportunity to fully comment whatever is the oral submission by the United States of America. Is there any comment to that, Mr. Harris?
No, none from our side. That sounds very sensible. Thank you.
Very good. And Mr. Ordway, from your side?
We also agree and think this is a reasonable approach.
Excellent. So then let me give Mr. Harris the floor. Is there any other question you would like to raise, a procedural issue which you would like to raise at this moment?
None, sir.
Thank you. And Mr. Ordway, what about you?
We have no procedural issues at the moment, Mr. President.
Very good. Madam Secretary, is there any issue you would like to raise?
No issues at this time. Thank you.
Very good. So then, if you are all in agreement, we can bring in the first witness. And Mr. Ordway, we have had some deliberation in the tribunal about the correct pronunciation of Mr. Zuich. We really, maybe do you have privileged information about the proper pronunciation?
The proper pronunciation is Zuich, with a
Zuich.
hard, yes, the hard end to it, Zuich.
Okay, very good.
Mr. Chairman, it's Mr. Yohai. I will be handling Mr. Zuich as the first witness.
Very good. Excellent, Mr. Yohai.
Mr. President, we'll let the United States back in as well as the witness.
So, yeah, maybe we let in first the United States.
Sure.
And then Mr. Zuich.
Good morning.
Matt, would you mind? Perfect.
Mr. Zuich, we will put you for 5 minutes into the fridge, if you don't mind, because we have an announcement to make to the United States of America.
Okay.
Thank you for your patience.
Okay, no problem. He is in the waiting room.
Thank you.
Mr. President, the United States is present in the main room now.
So I extend a warm welcome to the United States of America. The tribunal has deliberated and then has had a discussion with the parties. And if that is agreeable to the United States of America, the opportunity to make oral submissions to the tribunal in the course of this hearing, we thought that the best moment would be tomorrow, Friday, and I now am in the hands of the secretary, it would be 9, because we are starting tomorrow. Is it 8:30 or 9 US time?
9 o'clock.
9 o'clock. Thank you. So it would be, yes, 9 o'clock, 9 a.m. Washington time. Ms. Pines, that is correct, no?
Yes, that is correct.
So if, yes, now I can see you, Ms. Thornton, good morning to you. Would 9 a.m. tomorrow be agreeable to the United States of America?
Yes, that works for us. Thank you very much.
Very good. So then tomorrow at 9 a.m., we will give you the floor. With that, if we can now call in Mr. Zuek.
Good morning.
Mr. Zuek, good morning to you. Thank you very much for being here with us as a witness. As a witness, the first thing we have to do is we have to take your oath. So I will kindly ask you, Mr. Zuek, can you raise your right hand and can you take your oath in accordance with the declaration which you should have in front of you in your screen?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. Thank you very much, Mr. Zuek. Mr. Zuek, you are being, we have a court reporter, and what you are saying is being transcribed, and there is also a video, and so there will be a video, and you should know that the video will eventually be put on the web through the ICSID Secretariat. Mr. Zuek, before we start, I have to give you a number of instructions. The first one is that any communications between you and anyone else during the examinations is prohibited. And I have to ask you to affirm that you will not receive or provide any communication, be it oral or written, e.g. WhatsApp, any internet messaging, any sort of communication between you and anyone else in the course of these examinations. And reminding you that you are under oath, can I kindly ask you to affirm that you will adhere to this obligation?
I affirm that I will adhere to that obligation.
Very good. And you shall be visible and remain visible at all times during the examination. So if for any reasons you have to leave, of course, fully understandable, but you please, you say, can we have a 5-minute break? And of course, we will have that, but otherwise, please keep your screen on. And you have no virtual background. I see that that is another requirement that our procedural order establishes, but I see in the back of your room. And Mr. Zuek, last, you are alone in the room in which you are now.
Correct.
Thank you. Thank you, Mr. Zuek. Mr. Zuek, there are, I suppose you can see the whole screen. You will see Mr. Yohai and Mr. Ordway, who are counsel to claimant, and I think you know him. I think Mr. Yochai will be starting making you some questions. Then you should see Mr. Christopher Harris, QC. He is the counsel to the Kingdom of Morocco, and I understand, Mr. Harris, that it will be you who will be putting some questions to Mr. Zuek. Yes, I see the affirmation. Mr. Zuek, and I would kindly ask you for the following, and that is most questions to you will be put in a way which can be answered with a yes, a no, or I don't know.
Okay.
Because that's the normal way of putting questions by lawyers. Can I kindly, so that the transcript is clear, could I really kindly ask you that you first say yes, no, or I don't know, or I don't remember. And then you are most welcome to add any clarification, additional explanation which you would like to put.
Okay.
Thank you very much. And if you need anything in the course of the examination, I'm here, and you will see my two colleagues, Professor Grijera Naon and Mr. Sam Wordsworth, QC, and you have them. They are here also on the screen. You also have our secretary, that is Ms. Rosenberg from ICSID, and you have the assistant to the tribunal from my firm, Dr. Sierra de Cardoso, and you see our court reporter now, Ms. Diana Burton. So that is the screen you have in front of you.
Great. Thank you.
Very good. So, Mr. Yochai, your witness.
Thank you very much. Mr. Zuick, could you state your full name for the record, please?
Christopher Zuick.
And you have provided 3 witness statements in this proceeding, have you not?
Yes.
Okay, are they correct, and do you affirm them?
Yes, I do.
Okay, can you remind the panel, please, where you are currently employed?
Yes, I'm currently a partner at ESM Management.
And what is ESM Management?
We are a fund management company. So.
And where were you employed immediately prior to that?
Yes, from December of 2005 through June of 2016, I was employed at CCM or Carlyle Commodities Management, and its predecessor firm, Vermilion Asset Management.
And what was your role at Carlyle Commodity Management?
My role was, I had 3 primary roles: the Chief Compliance Officer, Chief Operating Officer, and Chief Financial Officer.
And where was CCM located?
CCM was located in New York City.
Did you have any other roles at any entities affiliated with Carlyle?
Yes, for each of the fund structures that we set up, we had multiple entities that were known as the general partners of those entities. The general partners of those entities also had similar structures, so identical structures to CCM. In addition to being the different roles that I had, I was also a partner at CCM and a partner for each of those general partner entities.
What was one of the partner entities you mentioned, Celadon Partners, LLC?
Yes, it was.
And what was your role in Celadon Partners, LLC?
I was a partner in that.
Okay. Did there come a time when CCM and Celadon Partners became involved with Samir?
Yes. Basically, in late 2014, we established a relationship with Samir.
Okay. And what was their involvement with Samir?
So CCM, from our perspective, was kind of, we looked at things very holistically. So we had a number of different funds and different investment entities that we were managing. We were looking to have cash that was invested in physical commodity transactions. And so basically in our role there, we were looking to make these investments with the Samir refinery in Morocco.
Could you describe, please, for the panel, the Celadon entity structure?
Yes, the Celadon structure was what is commonly known as a master feeder structure. The structure is commonplace in terms of how to set up what's known as a hedge fund. And basically, the idea of the structure is to facilitate the investments for both U.S. Taxable and U.S. non-taxable entities. And the way the structure is set up is that you would set up an onshore feeder fund. In this case, the onshore feeder fund was Celadon Fund Limited Partnership. An offshore feeder fund, in this case, it was Celadon Fund Limited, and an offshore master fund, and the master fund is Celadon Limited.
What role, if any, did you play in forming this structure?
I formed all of the structures, and not only those funds, but all of the funds that CCM formed.
And where did you do that from?
From New York City.
Okay, could you explain the specific role of Celadon Partners in the structure?
Yes, Celadon Partners is the general partner, or was the general partner, for the onshore feeder fund, being Celadon Fund LP. The primary role that the general partner played was to appoint the investment advisor. The investment advisor in this case was CCM, which was appointed by the general partner.
And who was the limited partner in the partnership?
The limited partner was the State of Maryland Retirement Pension Plan.
Now, what were the powers of the general partner as compared to the powers of the limited partner?
The limited partners had essentially no powers. The power that they had was basically to receive all of the economic benefit from the fund. The general partner was responsible for the management of the partnership.
Did the limited partner have any management responsibilities at all?
No, none whatsoever.
Okay. Now, how did this structure go about raising funds?
So CCM, our business was to basically manage investments. So the first thing we would do is go out and actually raise funds from outside investors. And in this case, we raised money from the State of Maryland Retirement Pension Plan. Those funds were then invested into the Celadon Fund LP, which was the onshore feeder fund.
Okay, and what did the onshore feeder fund do with those funds?
So CCM was responsible for making all the investment decisions on behalf of the onshore feeder fund. So what we did was we invested all of the money that was invested by the State of Maryland into the Celadon Fund LP, into the master fund, and that's Celadon Limited. And in exchange for that investment, Celadon Fund LP received participating shares of the master fund.
And what did the master fund then do with those funds?
So basically CCM, as the investment manager of the master fund as well, directed investments at that level. Some of those investments included investing in various futures contracts in order to mimic a index that we were trying to beat, and some of those funds were ultimately invested in a special purpose vehicle that we use for making investments in physical commodity transactions.
What was the special purpose vehicle used in the Samir investment?
I don't recall the exact name, but it's something like VMF, Special Purpose Vehicle, SPC Q1 vehicle.
Okay, and when were the funds put by the master fund into VMF Q1 for the Samir investment?
That was in the spring and early summer of 2015.
Now, did the Q1 fund have any employees?
No, none of our funds had employees.
Did the Q1 fund have any separate financial statements?
No, in discussions with our auditors of our various funds, which in all cases was basically Ernst & Young, we determined that the audits of the funds investing into the Q1-like vehicles did not require those vehicles to be audited, but they could actually look through during their audit to see the transactions at those levels and roll them up into the master fund audits of the various fund vehicles.
Did Q1 have any infrastructure or any offices?
No, it did not.
Okay. In addition to the Celadon entities, there were certain entities called the notes entities. Could you describe their role in a little more detail?
Sure. Again, from our perspective, we had various different investment entities. Many were master feeder structures. Some were standalone funds. And then we had these structured notes that we introduced into our investment portfolio in 2014 and 2015. These were structured notes that specifically were designed to make investments in physical commodity transactions.
Did you have any role in forming the notes entities?
Yeah. Yes, I did. It was my actually idea, and I was the driver behind forming all of those investment vehicles.
Did the notes entities have any employees of their own?
No, it did not.
Okay. Now, directing your attention back to the end of 2014 and early 2015, can you describe how the Samir investment began, please?
Sure. Again, as part of our sort of investment management of all of these funds, what we were looking for was for counterparties where we could make investments in physical commodity transactions that were structured particularly in a way that we wanted them structured. I don't recall the exact way. We were introduced ultimately to Samir in late 2014, at which time we decided to pursue a relationship with them whereby we would enter into investments, basically holding physical commodity transactions at their location. And that was basically, the nexus of how we started.
Was there any contact with the Moroccan government during the early stages of the Samir investment?
Yes, prior to being able to enter into any of the transactions that we contemplated, the transaction structure needed to be sort of blessed, I guess, by the Moroccan government. So we met with people from the Ministry of Finance, specifically their foreign exchange office, where we described in detail the structure of the transactions. One of the primary key points of the transaction was that we were taking physical delivery as well as ownership and title to the commodities, and all of those things were understood and ultimately approved by the foreign exchange office.
How long was the Samir relationship supposed to last?
With any relationship that we got into, we weren't interested in small or short-term transactions. So we were always contemplated long-term transactions. So in this instance, we contemplated multiple years. And in fact, at some point in time in the summer of 2015, we entered into a commitment agreement with Samir, whereby we anticipated that relationship lasting at least 3 years from that point.
Can I ask Kim, please, to put up CZ04? Do you recognize this document, Mr. Zwick?
Yes, this is the commitment letter that I just mentioned previously.
Okay, and can she call out, please, paragraph 1A? Could you explain to the panel, please, your understanding of this paragraph 1A?
Sure. This was basically, the primary focus of this commitment letter, which is where we, being Samir and CCM, were entering into, which at that time was still Vermilion Asset Management, we're entering into a commitment to provide them with a significant amount of investment over a period of 3 years.
Was the length of the investment important to CCM?
Yes, it was. The basis of our business, specifically on the notes side, but also as it related to all the other funds, was that we were looking for the ability to invest our cash into these types of transactions. Making a decision about whether or not to raise more money or more cash was very much dependent on how many of these relationships we could establish and how large and how long they would last.
Did the investment in fact go through June of 2018?
No, it did not. From my personal perspective, it effectively ended in early August of 2015 when the Moroccan government effectively shut down the refinery and has shut down Samir's abilities to make any payments to us.
Okay. Can you tell us who specifically at CCM made the investment decisions as it relates to the Samir investment?
I did.
Okay, and where did you make those decisions from?
From New York, from our offices in New York.
Now, at times, Morocco has suggested that CCM had no financial stake in the Samir investment, given the structure. Is that correct?
No, that's not. Again, from our perspective, these were relationships between our counterparties, in this case, Samir and CCM. Our role in this was to manage the investments, across the different investment vehicles, but we were the ones that were facing Samir. When this loss happened, we effectively lost the oil in this case, and as a result of that, we basically went out of business. It was not possible to survive a $400 million loss.
Mr. Zwick, at times Morocco has suggested that the losses here were only sustained by Q1. Is that correct?
No, it's not. The way these structures worked is that even if a loss occurred at in a certain vehicle, you had to look at exactly the economic relationships between the different vehicles in order to understand who was actually taking that loss. In this case, you had basically Q1, which was invested into by the Celadon Master Fund, Celadon Limited, in exchange for its investment of capital into that fund. It received participating shares. Those participating shares are the shares that basically, receive the economic benefit of these transactions. As I mentioned earlier, the onshore master fund, Celadon Fund LP, had invested in the master fund its assets in exchange for participating shares in the master fund. Same exact structure. So basically, you had the losses move up the chain, and ultimately, the loser, of this was the state of Maryland pension plan.
Okay. When you talk about the structure, can you explain, please, who amongst the various entities you think suffered losses here?
Sure. I mean, ultimately, it's who suffers losses at the top. So in this case, the state of Maryland retirement pension plan, the Carlyle Commodity Group, we suffered a significant loss. Carlisle itself also suffered losses. They were invested in the structure. I personally suffered losses. I mean, yeah.
Okay. There are two other claimants here, TC Group and TC Investment Holdings. Can you explain their role?
Sure. They were the majority owners of CCM. And in addition to that, they were in the whole owners of the offshore feeder fund, which is Celadon Limited, or Celadon Fund Limited.
Okay. Did the onshore feeder fund suffer losses here as well?
Yes, it did, through its participating shares in the master fund.
Okay. And what about the Carlyle Group? Did it suffer losses as well here?
Yes, it did.
Okay. My last question, Mr. Zwick, bottom line, who in your view controlled the investments with Samir?
CCM is the controlling entity here. You know, the investment vehicles that we have are entities that have no employees, no decision-making powers. All of the investment decisions were made by CCM.
Okay, thank you. That is my 15 minutes, Mr. Chairman, which I agreed to accede to. So I will be back perhaps on redirect.
Thank you. Thank you, Mr. Yochai, for also sticking to the time, and thank you, Mr. Suick, for being also very precise in your answers. So with that, I now give the floor to Mr. Harris, whom I don't see, but he must be somewhere. Yeah, now I see you. Mr. Harris, I assume you have some questions for the witness.
I do indeed. Good morning, Mr. Zuick.
Good morning.
My name is Christopher Harris, and as you've been told, I'm counsel for Morocco in this case, and I'm going to ask you some questions. Before I begin, can I just ask you one thing? Forgive me, I got the impression during your direct that you might have been reading something on the desk in front of you. Can I just confirm with you that whether you were or not?
No, I was not. Sorry, I tend to
look down.
I have a pretty, no, I mean, I'm happy to kind of show everybody.
That's fine.
This is my desktop.
Just
Nothing going on there. So
good.
Okay.
Now, you've just given some evidence about the transactions, and I'd like to pick up on some of that. You were involved in the paperwork underpinning these transactions, weren't you?
Yes, I was.
Yes. In fact, that would have been a fairly important part of your role as COO and Chief Compliance Officer, I'd have thought.
Yes.
And I think it's right to say you signed the MCTA, yes?
Yes.
And you signed the CSA as well, the Commodity Storage Agreement?
Yes, I did.
And presumably you familiarized yourself with the content of those documents before you signed them?
Yes, I did.
And the purpose of the transactions that were being entered into with Samir was to provide Samir with liquidity, wasn't it?
Yes, I mean, from Samir's perspective, I think it was that they were looking at this as a way for them to basically receive liquidity, as you said. From our perspective, these were strictly, you know, sort of investments.
Now, you mentioned in your direct a document CZ001. You refer to this letter for the Office d'Échange, your exchanges with the Office d'Échange.
Yes.
And there's a document that we can look at that you've exhibited in relation to that. Can we bring that up on the screen, please?
Please don't ask me to read the French part.
Don't worry.
Okay.
Now, you're familiar with this document, aren't you, Mr.
Yes.
Zurich? And it's right to say, as I think you just told us, that this followed meetings that you'd had and Samir had with the officials of the Office d'Échange, the Foreign Exchange Bureau, yes?
Yes.
And if we look at the subject line, it says opening a credit line of $350 million on behalf of your company in relation to your crude oil imports. Do you see that?
I do, yes.
And then if we go down a little bit further, it sets out what the Office d'Échange has been told by you and Samir about the main features of this credit line.
Yes.
And the second bullet point says for each import operation, VAM will issue a letter of credit in the name of Samir to a top-tier foreign bank in favor of the foreign supplier, covering the whole FOB value of the crude oil shipment being imported. Yes?
Yes, that's what it says, yes.
And then in the next bullet, the third bullet, it says that by way of guarantee, Samir has to transfer the ownership of the commodity to the Vermilion VAM party, yes?
Yes, I think that's the critical point for me.
Yes, and then the fourth point talks about Samir having to pay 6% of the value of the shipment in cash as an advance on the security deposit once the import operation is completed, yes?
Yes.
And the fifth bullet refers to the repayment term being between 90 and 120 days. So that's the period over which these transactions were expected to be open, yes?
Yes.
And the sixth bullet talks about the interest rate for the credit is set at LIBOR plus 4.75%.
That's correct.
Yes?
Yes.
It's fair to say that the Office d'Échange is understanding this as a secured financing facility by Carlyle to Samir, isn't it?
Well, I think the key point when I look at this, and this is really the only thing that ever mattered to us, is really in the second bullet point that you highlighted, and that is that they understand that we own the commodity, that the basis of this is Samir must transfer ownership of the imported crude oil shipments within the framework of our agreement to VAM. And I think that that's the most key point. This is, when you transfer ownership of something, Samir no longer owns it. We own it. It's our commodity. And from my perspective, they fully understood this. When I look at this, it's always difficult. Look, when we set up these transactions, they were specifically set up not to be financing transactions. They have an option component, which is very critical to that. We had a legal opinion written that said these are not financing transactions. These are true sales between our counterparty and us. And for me, them understanding that we own these commodities was the most important thing. How they interpreted the rest of our relationship, I was less concerned with.
Mr. Zurek, just reminding you of President Armesto's guidance at the beginning of your examination. Do I take it, I just want to be clear about what your evidence is, and you gave a long answer, but no yes or no in it. So let me put the question again.
Sure.
And see if you can start with a yes or no. Do you accept that on the basis of this letter from the Office d'Échange, what they understand this transaction to be is a secured financing by Carlyle?
Objection.
No.
Objection to the question, Mr. Chairman. He's asking the witness what the understanding is of Morocco, which the witness could not possibly give the understanding of Morocco. So I don't know how he can answer that, yes or no.
Yes. In any case, I think the letter speaks for itself. And I think I wonder, Mr. Harris, if we can, except for he has given, the witness has given an explanation what was important to him. And I think the letter speaks for itself. I wonder if we have to go deeper into this issue.
Well, I'm happy to move on, but it's perhaps worth just keeping in mind the guidance that President Armesto gave you at the beginning to give a yes or no answer and then the explanation.
Okay.
Now,
yes. I think this is a reasonable summary, and but I think the letter, it's a short letter. There has been quite some discussion on it, and I think we can move on.
Now, let's look then at the terms which govern the transactions that were being entered into, and they were in the MCTA, and the 22nd of June 2015 version of that document you've exhibited at CZ002. We'll bring that up on the screen. If we go to page 14 of that, we'll see your signature at the bottom.
Yes.
That's your signature, isn't it?
Yes, it is.
Now, the tribunal, as we said earlier, we can take it that you read this document carefully before you signed it, can't we?
Yes.
And that you were happy with the terms of that letter as reflecting what was going to happen.
Yes.
If we go back up to the second page of this PDF, it was initially an agreement between VM Party and which is then defined, and Samir, but it was intended that the agreement should be capable of being entered into by one of a number of entities. Yes?
Yes. I think towards the bottom of that paragraph, it says VM Party means entity advised by VM.
Yes. And it says in the first line, VM Party is pleased to confirm the terms and conditions on which VM Party may from time to time during the term of this amended MCTA enter into transactions with Samir, whereby VM Party acting as principal and subject to the terms blah, 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 may purchase all of these different things. Now, VM Party was in fact Q1 under this agreement generally, wasn't it? That's the SPC vehicle that you designated, as far as we're concerned in this case. Appreciate there might have been other transactions that we're not concerned with. And as we saw, the VM Party would be acting as the principal in relation to each transaction. Perhaps we can just highlight that so that you can see that. It's further up. It's the fourth line, end of the fourth line, whereby VM Party acting as principal. You see that?
I do, yes.
And the MCTA, it was a framework agreement, wasn't it?
It was the agreement that, yes, it was the agreement that we determined, or that laid out the rules under which we would transact with Samir.
Yeah, and then you would have individual transactions dealt with in confirmations underneath the MCTA.
Yeah, yes.
Yeah, and we can see that in clause 2A. We go over the page. If you want to do a transaction, you send a confirmation setting out the detail of that transaction. And I think we looked at with the tribunal yesterday. I assume you don't need to see it. Page 15, there's a standard form confirmation that was intended to be used. Do you recall that?
Yes.
And effectively, the relevant party would indicate the commodity it wanted to buy, the amount of it, purchase date, etc. Standard finance industry type document. Yes?
Yes.
And is it right as well that for each transaction there was something called an exercise period?
Yes.
And that was the period, effectively the period of the financing during which the VM Party was able to exercise its put option right. Yes?
No. Well, yes, I would object to calling it a financing transaction. That's me personally. These were structured transactions, specifically not financing transactions. Again, I mentioned we had a legal opinion explicitly stating that these were true sales and were not financing transactions.
Well, we'll come on to that. I understand why you're very nervous about them being financing transactions. Now, what we see here on the screen is that after a confirmation has been fully executed, the commodities are then purchased. Yes?
Yes.
And it says here that the commodities are purchased by Samir, which is then obliged to provide evidence of the purchase to the VM party. Do you see that? It's at 3, clause 3.
Well, in this instance, I think you misclassified it. Sorry, you said Samir purchases we purchased the commodity from Samir.
Yes, you purchased the commodity from Samir.
Yes, yes.
Yeah. But the but Samir had to purchase them first for you to be able to purchase it from Samir, didn't it? Samir must have had them for you to purchase them.
Yes.
Right. And if we go down to 3C, on the day of delivery, you pay the purchase price to Samir. Yes?
Yes.
And title then passes in the commodity to VM party. Yes?
Yes.
And if we go on to clause 9, we can see that you had rules about while the commodities are being held by Samir in its tanks thereafter, if any commodities are going to be held by Samir after you've purchased them, they will be, to the extent physically and economically practical, they will be segregated from other commodities owned by Samir. Yes?
Yes.
And if we go back up to 3E, now this is the point about the exercise period. During the exercise period, at any time in that period, the VM party could exercise a put right, which would then allow it to sell the commodities to Samir. Yes?
That is correct. Yes.
And to pick up on the point you made earlier, if we just go on to clause 16D on page 10, this paragraph, if you just have a quick look at it yourself, and then I'll ask you a question about it.
Yes.
There are two elements here. The first is that you record that it's both parties' intention that this shall be treated as a true sale and shall constitute a true sale. That's the first bit, yes?
Yes.
And the second bit is, if, despite that intention, any purchase is deemed to be a financing involving the extension of credit by VM to party to counterparty, or if for any reason ownership's not vested in VM party, the payment of the purchase price shall be deemed to be the incurrence of an obligation for borrowed money by counterparty in favor of VM party, with the interest of VM party in such commodities being deemed a first priority perfected security in such obligation. Do you see that?
I do, yes.
And that's why you were concerned to structure these as sales, because there is a problem that has arisen in some of these types of commodity financings where they are deemed to be a financing, not a sale. And that means you don't have a proprietary interest, and that means you're an unsecured creditor. Yes?
No. So this language was put in here as sort of belts and suspenders. As I said, when we structured this transaction, it's very clear that we could not enter into financing transactions. And the reason for that goes to US tax. If it's a financing transaction, then the fund itself is deemed to participate as a trade or business for U.S. tax purposes and becomes subject to tax. So in the structuring of this transaction as a true sale, it was imperative that that was the case. This language was belts and suspenders language that we put in. We never thought that it would ever be necessary because, again, we had the opinion that this was a true sale, a tax opinion from law firm, again, just put in as belts and suspenders. This was never the intention for this transaction to operate under this particular paragraph.
Well, let's look at the reality of how this all worked in practice. In reality, all 16 confirmations relevant to this dispute were entered into by Q1 as the VM party, weren't they?
Yes.
And we've seen that under the NCTA, what's supposed to happen is Q1 is supposed to purchase commodities from Samir, yes?
Yes, under the transactions, we actually did purchase them, yes.
It was a slightly different transaction, wasn't it? Because what actually happened was 2014-1 issued a letter of credit to a seller of a commodity to finance Samir's purchase of that commodity, didn't it?
No, I don't agree with that. We posted a letter of credit, and
can you be precise when you say we?
Sure.
Who posted the letter?
CCM, again, I looked at this very holistically. Okay, I had a relationship, meaning CCM, with Samir, and depending on whatever the day was, depending on the cash availability of a different investment vehicle, depending on the risk parameters and the amount of exposure that these things had, it was my responsibility to find, whatever funds that I needed in order to enter into a transaction. We posted the letters of credit in order for Samir to be able to purchase the commodities. And, in the physical commodity space, and this is beyond my area of expertise, and this is why I had people working for me who handled this. There's something basically known as a flash title transaction. And so at the end of the day, when the commodities showed up, which we posted the letter of credit for, the title for those commodities transferred to Samir and then instantly transferred to us as part of the purchase from us. And so we were posting the letter of credit, but in terms of actually achieving the sort of perfected, we own this commodity, that happened when the commodities arrived in the port in Morocco, or if Samir took title to the commodities on a vessel, then as soon as they took title to that commodity, with the transaction in place, we instantly at that exact same point, and like I said, it's, commonly referred to as a flash title exercise. We took title to those commodities. So the fact that we were providing the letter of credit, that's all that is a letter of credit. It's basically saying to a supplier, to Samir, saying, hey, we're not going to supply you with oil unless you post the letter of credit. We would post the letter of credit. Samir would take ownership of the oil and instantly transfer that ownership to us. Sorry, long answer.
Let me pick that apart a little bit. The supplier in that example you just gave, 2014-1 issues the letter of credit to the supplier. Let's say it's Total, and you're not suggesting that Total didn't draw down on that letter of credit, are you?
In a lot of cases, they don't draw down on the letter of credit until they actually deliver the commodity. So again, if you're posting a letter of credit, this is my understanding that you're, and I'm not a physical commodity sort of specialists in terms of this, but you're basically posting the letter of credit in order for Total to load out a vessel with oil and deliver that vessel to Samir. So what Total doesn't want to do is load a vessel of oil without a letter of credit, because they're saying, if I load this vessel of oil that I'm going to sell to you and you ultimately don't pay me, now I have a vessel of oil that I have to deal with, and that, you know, can be viewed by the market as a distressed asset, and I may have to sell that for less. So they require a letter of credit to be posted in order to load out the vessel. As soon as the title for that transfers, that's when the payment is made. And that payment, you know, which may have been made by drawing down on the letter of credit, basically at that exact same time is when we transferred the title, or title was transferred to Samir and then to us.
Can I just try and get a very precise answer to my question?
Sure.
Is it your evidence that in any of the 16 transactions we're concerned with in this case, payment was made by Samir for the commodity rather than payment being made under the letter of credit?
No, that's not what I'm saying. I'm saying that the letter of credit was that the draw or the payment under the letter of credit took place at the time simultaneously with the supplier transferring title of the commodity to Samir and Samir transferring title to us. And so that was all done, you know, sort of instantaneously. We did not take title from Total. We took title from Samir.
Let's look at an example. If we can pull up C0045 on the screen. If we go down to page 2 of this document, this is the letter of credit application for Samir 1005 transaction. If we go on to the next page, the party applying for the letter of credit is 2014-1.
Mm-hmm.
You see that?
Yes, I do.
And it's for the account of Samir, yes?
Yes.
In favor of the beneficiary, in this case, BP,
Yes.
Oil International. Yes?
Yes.
Now, BP Oil was the party selling the relevant commodities in the context of this transaction, 1005, yes?
Yes.
Now, what this means, and I think what you just explained, is that Samir wasn't the party initially purchasing this commodity. It was 2014-1, because it's provided the letter of credit under which payment is made for the commodities. Yes?
No. Samir is purchasing the oil. We're posting a letter of credit in order for them to load out the oil to deliver to Samir. And when they drew down on the letter of credit, the title transferred to Samir. That's all that BP know. We had no relationship with BP. BP was delivering the oil to Samir. And then under the transaction agreement that we had with Samir at that point in time, we would purchase the oil from Samir.
The party, there's a divergence in practice from the terms of the MCTA, because the party which entered into the confirmation, which is Q1, didn't issue the letter of credit which financed the transaction, did it?
So first of all, like, again, I looked at this holistically. We had one LC facility that was under 2014-1. So we utilized that facility. It could be that that Q1 actually transferred money into 2014's account. You know, that's we did that commonplace. And the key thing is that when the actual payment was made, the title at that point in time was transferred from Samir to us. The letter of credit was just put in place to facilitate the delivery of the oil to Samir. And then once that was done, our counterparty, or on our fund on our side, which in this case was Q1, would buy the commodity from Samir. And that all just took place instantaneously. It wasn't, we didn't move money into an account. We didn't do this. This is just kind of like, exactly how this worked.
But the reason that 2014-1 was posting the letter of credit, under which the funds were then drawn down from 2014-1 by the supplier, was because Samir couldn't pay for the product itself, wasn't it?
I don't know why Samir would have or not have been able to pay for the oil itself. It's simplified the transactions from our perspective, because as soon as the oil was taken into Samir's ownership, the ownership was transferred to us. I mean, it's not, again, a letter of credit, has two sides to it. Just keep in mind, if the counterparty or the beneficiary of the letter of credit here, so if BP fails to deliver the oil, they can't draw on the letter of credit. They can only draw on the letter of credit once the oil is transferred to Samir. And once that happens, then they can draw on the letter of credit. And once that happened, at that point in time, simultaneous with that, Samir took title to the oil and transferred title to us via the transaction.
Mr. Harris, can I make a question to the witness?
Of course, sir.
Could I kindly ask someone in your team to go to the second page of the LC? Mr. Zwick, are you an expert? I mean, have you ever worked with LCs?
No, I actually had a team of people that were experts in this, that worked for me, that did this. So again, I'm not an expert in this.
But you know what a marine bill of lading is?
Yes, that meant that was the marine bill of lading is basically the title documents while this is on a vessel. And
I was just looking here, I don't know if you have had the opportunity of looking at, this is some time back, and I'm completely, it's clear to me that you were chief executive officer, so you may never have got into this detail,
right.
But it struck me that you see that the document, this is payable against a commercial invoice. You see it in 15, the first box. Maybe someone can highlight that.
Yes, I see it, yeah.
And then you need a certificate of quantity. You see that in the middle.
Yes.
And then you need a marine bill of lading.
Yes.
That's the third set.
Yes.
And then if you go further down, there is a small on the left. It says, there it is, for marine bill of lading. It says consigned to the order of Carlisle Global Market.
Yes.
And that's Q1.
Yes.
That's 2014 one.
That's 2014 one, yes.
So my question to you is, the way normally you're titled to oil cargoes,
yes.
It goes with the marine bill of lading.
Yes.
So if I look at this, what BP will do when they put in the oil, wherever it comes from,
yes.
They issue the marine bill of lading.
Yes.
They issue it in the order of 2014, to the order of 2014-1. Mm-hmm. So it is 2014-1 who will receive title to the commodity.
It's possible.
Is that your understanding?
It would be possible that were the case, and then at that point in time, we ourselves would transfer the title, endorse the title over to the Q1 vehicle. So a lot of this had to do with just basically the administrative side of managing multiple pools of cash across multiple vehicles. As I mentioned earlier, the only letter of credit facility that we had set up was for the 2014 one. You know, it takes a lot of time and effort to set up LC facilities, which is the reason that we utilize this one. But internally for us, if we had received the bills of lading, they were made out to 2014, we would have endorsed them over to Q1.
Very good. Thank you.
Okay.
Mr. Harris, sorry for the interruption.
Not at all. Mr. Zurich, can I just, the point here is Q1 never paid Samir for any of this oil, did it?
No, I don't think that's true. I mean, as I said, you know, we utilize this letter of credit, and Q1 may have actually made the payment through the 2014 account.
Direct payment from Q1 to Samir, to your knowledge, in relation to any of these transactions, was there?
I would have to, not to my recollection now.
And just before moving on, just one question on the last three transactions, which are the commodity swaps. There, no letter of credit was issued in respect of them, of course. Yes?
That is correct.
And so those swaps were not done pursuant to the terms of the MCTA, were they?
No, that's incorrect. They were. Basically, we had open oil transactions, and basically what we did was close out the oil transaction, and at the same time open a new trade with whatever the underlying refined product was, like distillates or fuel oil or something of that nature. And so those two things netted out, so there was never a transfer of cash, but yes, we closed out one trade and opened a new trade.
It's right, isn't it, that the MCTA doesn't mention...
Sorry, Mr. Harris, I'm very sorry, but I will need that Mr. Suek explains this again, because yesterday I did a similar question and I understood that there was a cash, that cash was in fact used by Q1 to finance the swaps. And can you go in some detail through the three swaps, Mr. Suek, for someone who is not a commodity trader?
Sure. Apologies, because I
don't have everything. Apologies for not understanding it.
So, you know, keeping in mind that, you know, from our perspective, we're dealing with Samir, which is a refinery. So they're going to have basically two commodity, obviously more than two, but two commodity products, right? They're going to have their inputs, which are oils, and they're going to have their outputs, which are refined products. And so at various times, it was always contemplated that we would enter into transactions where we purchased the oil, and then there would be times where we would contemplate purchasing refined products. Because they're a refinery, and you know, things are open, and when they're open, they're moving, they're drawing down oil, they're creating, you know, refined products. At some point in time with the swaps, we made the determination that we would sell them back the oil and purchase at the exact same time the refined products. I apologize because I don't, you know, I don't have the bank accounts in front of me. It's been 5 years. I don't know, you know, exactly whether or not cash moved between those two, but essentially what happened is that we closed out the transaction, and then at the exact same time we opened a new transaction. So the only amount of cash that would move would be the amount of money that would be the differential between the oil that we sold back to them and the commodities that we bought from them. My guess is that was zero, because I think we would have just purchased, you know, an equivalent amount of what the original open transaction was, so that we didn't have to move money. Another sort of simpler way of thinking about it is, instead of paying dollars, you know, for the oil that they bought back from us, they paid for it with refined products.
So to understand that, before, let's say Samir had 2 tanks. So before you owned 1 tank of crude oil, and
Yes.
after the swap, you were owning a tank with gasoline for
Yes.
the equivalent value of the tank of crude.
Yes, yes. So we no longer held title to the oil, but what we actually now held title to was the gasoline.
Exactly. And you had, again, a put option on the gasoline,
Yes.
so that at some stage you would then, could you exercise that put option to force Zamir to buy the gasoline?
Yes.
Thank you. Now I understand it. Thank you.
Okay.
Sorry, because yesterday I somehow got out of the hearing with a different idea. Has been very helpful. Thank you.
Okay.
Mr. Harris, sorry for the interruption.
Not at all. Now, you're also familiar with the sleeve transactions by which title arrived at 2014-1, yes?
Yes.
We just take a look at those quickly. They were governed by a document that we call the VM MCTA, and you've exhibited that at CZ0065. Can we quickly bring that up on the screen, please? You can see at the top of page 2 that the purchaser in this case is said to be 2014-1. You see that?
Yes.
And the seller is rather strangely identified as the master fund.
Yes.
That doesn't make much sense, does it, Mr. Zurek?
Can you look at the date? I'm sorry.
Yes, scroll up.
Is there a date on this?
Or maybe you have to scroll to the end. There you go.
Yeah, this may have been put in place before the Q1 was established. I don't know. You know, the timing of this is.
Okay.
It's been quite 6 years actually.
Mr. Zuek, I know it is slightly unfair to you to show you only documents which you cannot yourself see in their integrity.
Yes.
But that is technically not possible, that you can scroll down through the documents. So that if at any time you wish that counsel scroll down the document, or you need time to look at the document, please, we have all the time in the world, but
okay.
Take your time to look at the documents.
Okay.
Because I am perfectly aware these are 6 or 7 years back, and no one can remember everything.
Okay, thank you.
If we go back to the second page, that we're looking at before.
Yes.
The transactions contemplated followed a materially identical structure to the MCTA between Samir and Q1, which we saw earlier.
Yes, that's correct.
You have a master agreement with confirmations then being entered into to document each specific transaction. Yes?
Yes.
And if we go on to page 3, we can see some relatively familiar looking provisions at paragraph 3, clause 3. Here, you've got a complete sale of the entire beneficial interest in commodity for all relevant purposes. That each transaction is an absolute transfer of the entire legal and beneficial interest in the commodity, and not a transfer of security for a loan. Relationship is seller and purchaser. So very clear that what this document envisages is a transfer of title from, in this case, the master fund, later we say Q1, to 2014-1 of the title to the commodities. Yes?
Yes.
And then we have, let's just look at one of the transaction confirmations. Well, no, actually, in view of the time, let's not. But when 2014-1 received the title under one of these sleeve transactions, it then was also under an obligation to transfer the title to State Street Bank and Trust, wasn't it?
Yes.
That obligation arose from the indenture, which is CZ0050. Perhaps we can bring that up on the screen. And you can see it's between 2014-1 and the State Street Bank and Trust Company.
Yes. But I mean, I just would point out that I agree with you, but the trustee is not holding that for its own benefit. It's holding it for the benefit of the bondholders. You know, the trustee basically held all of the assets of the trust for the benefit of the bondholders. It's, you know, that's
generally what trustees do, Mr. Zurich.
Yes, yes.
That's generally what trustees do. But it was holding it. We can see, go down to page 9 of the PDF at clause 1. We can see the granting clause, which the issuer, subject to the priorities and exclusions of any specified below, the issuer hereby grants to the trustee for the benefit and security of the holders of the senior notes.
Yes.
There were subordinated notes as well, weren't there, Mr. Zurich?
There were, yes.
Yeah. So it's holding it for the holders of the senior note on trust. All of its right, title, and interest in, to, and under, whether now owned or existing or hereafter acquired or arising in the commodities, etc.
Yes.
And so what 2014-1 was doing was it had to transfer the title to the commodities to State Street Bank to hold on trust for the note holders. Yes?
I don't know, but yes, that's the way I don't know exactly how that happened, but yes, that's what ultimately the trustee was the one that had to do that, but I don't recall how we transferred that.
Now, while we're still on these transactions, you know, don't you, that the proceedings which CCM 2014-1, 2015-1 and Q1 brought in New York against the excess insurers were in the respect of commodities which were the subject of these same 16 transactions that we're concerned with here, weren't they?
Yes.
And what the New York court found was that in practice, there was a further divergence from the contractual scheme in that Samir was refining commodities before it paid Carlisle for them. Yes?
Honestly, I'm not familiar with the actual court ruling. I do understand that it's being appealed, number one. Number two, it from my perspective, it didn't matter what they were doing. They were violating the agreement. Our agreements were very explicit. They were not allowed to use our commodities without our written consent. That's very clear, and we never gave them written consent to use the commodities.
Well, let's look at the order of the New York court.
Sure.
That's at R006, and if we can go to paragraph 5 of that order of the New York Supreme Court. In practice, this is the determination of the court. In practice, Samir processed the oil and sold the resulting refined oil products on an ongoing basis without either payment to Carlisle or prior written consent, and then paid Carlisle at some point after the oil had already been refined and sold. So that's the judge's determination of what was actually happening. And that far, I'm not sure you disagree with that. That I think that is what happened.
I disagree with the characterization of it. You know, when somebody takes something from you and you're, you know, in violation of our agreement, and, you know, then you're trying to basically get paid back. I don't disagree that that may have happened, but it doesn't mean that we agreed to that. We never made that agreement. And you know, in practice, the fact that they did that Samir did that, and I think, you know, there's a letter actually from Samir sometime in September that basically says that they took the commodities without our permission. So they admit to that. So I'm kind of confused as to why it's even relevant. But
well, I'm just showing you what the court held, and I'm surprised that you find it difficult to agree the paragraph I've highlighted, because I thought that's what you thought was the position. The bit I thought that you disagreed with, but perhaps I'm wrong about this, was that the court's conclusion that Carlyle expected that the oil that it purchased and was delivered to Samir would be used in the refining process. I thought that was the bit that you cavilled with.
no, I agree that that's what the expectation was. They're a refinery. I expected them to do that, but I expected them, under the terms of our agreement, to purchase the oil back from us, to refine it, to use it. In practice, and I guess I would even sort of say it's not practice. In reality, what happened was that they actually, you know, took our oil, and once they took our oil, of course we're trying to get paid for it, but it wasn't like we determined that, okay, let's just do it this way. It was sort of unilaterally done by by Samir.
And it's right, isn't it, Mr. Zuick, that you at Carlisle knew that Samir was refining the commodities before it paid you for them, didn't you?
We found that out, but they didn't have our permission to do that. Yes.
And your colleague, Mr. Suvagia, he told the New York court, didn't he, that Carlyle knew that Samir was refining the commodities before paying for them? Yes.
Objection to the form of the question. The witness, I don't think, should be asked to comment on what some other person told to the New York court.
I'm asking him if he knew.
Well, okay, that's a different question.
I didn't know that. I didn't know that he classified it that way. I would not have classified it that way. He was relatively new to Carlisle, and I'm not sure why he would believe that was the case. Our agreements were very explicit that they could not do anything unless they had our written permission to do so.
So you, just so I understand, is it your evidence to this tribunal that you have no idea what evidence your colleague, Mr. Suvagia, gave to the New York Supreme Court in relation to a case where you're one of the key witnesses for Carlisle as well?
I did not read his statements to the court, no.
You have been very clear about my question. You have no idea what evidence Mr. Suvagia gave to the New York court?
Yes, correct.
Now, let's move on to talk about CCM's relationship with Q1 and 2014-1 in particular. But both of those companies, Q1 and 2014-1, they had their own directors in the Cayman Islands, didn't they?
Which entities? Sorry, 2014-1?
Q1 and 2014-1.
Yeah. So the directors for Q1, I believe, were in Curacao, not the Cayman Islands, and I believe the directors for 2014-1 were in the BVI somewhere. I don't remember.
Well, let me put it this way: they both companies had directors, didn't they?
Yes, they did. Yes.
And presumably, you're aware, given your role as chief compliance officer, amongst other things, that company directors have fiduciary duties of care and diligence and skill.
Yes.
And those directors had to exercise those duties in the best interests of the company of which they are a director. Yes?
Yes.
And let's look at the agreement.
make an interruption. I think someone is doing something which I may have done also, which is typing with the audio on and without the mute on. So if I could kindly ask whoever is typing with to put on his mute. And I know I do this from time to time, and I apologize. And please advise me when I forget to put the mute before typing. But otherwise, we hear the typing, everyone concerned. Sorry for the interruption. Thank you.
Not a problem. The first agreement I'd like to look at is the agreement, the contract between Q1 and CCM, and that's at Exhibit CZ 47. And if we go down to page 13, we can see your signature at the bottom, I think.
Yes.
On behalf of Vermilion Asset Management, which I think is CCM, isn't it?
Yes,
Later.
it is. It's a predecessor company, yes.
And we see Eric Anderson. He's the director of Q1, yes?
Yes.
Now, just so I understand your evidence, is he a nominal director who just did as he was told?
I wouldn't classify it that way. But the directors had no input into the day-to-day business that the funds transacted. They basically, through actually this agreement, ceded that authority to Vermilion.
Well, let's look at that. We go back to recital B on page 2. See that the company, that's Q1, it wishes to engage the investment manager to provide investment advisory services with respect to the segregated portfolio, and the investment manager wishes to accept such an engagement. Yes?
Yes.
And Article 1 sets out that CCM is to be a limited attorney in fact. You see that?
I do,
the
yes.
CCM is going to be its limited attorney in fact to invest and reinvest the net assets of the segregated portfolio. And this is a continuing power and shall continue in effect with respect to the investment manager until terminated pursuant to the terms of this agreement. So the power only lasts as long as this agreement remains in force, yes?
Yes.
And the types of activity to be undertaken by CCM are set out at Article 2. And we can see the various things there if we scroll down the page. It's a very long and detailed list of things, yes?
Yes.
It doesn't allow CCM to do whatever it liked with Q1's assets, does it?
No, it had to fall under these provisions.
Yes. You couldn't have used the cash of Q1 to buy yourself a house, for example.
No, I could not.
No. Or to go and buy a business for CCM in Morocco.
I would have to look through, but I don't know where it would fall into or.
Well, let's put it
Yes.
let's put it in a different way.
Okay.
You had to stick to the types of investment which you were authorized to undertake.
Yes.
In this agreement. Yes.
Yes. Yes. Correct.
And at 3A, you can see the parameters within which the activities were to be pursued. All the activities engaged in by the investment manager on behalf of the company shall be subject to 1, the company's organizational documents, 2, such policies as may be adopted from time to time by the directors, and 3, all provisions of applicable law.
Yes.
So CCM's activities as investment manager was subject to any decisions made by Q1's board of directors. That's number 2. Yes? See that?
I do.
So if the board of Q1, the directors of Q1 adopted a policy not to invest in the arms industry, for example, or the tobacco industry, you wouldn't be able to, at CCM, to invest in those industries on behalf of Q1. Yes?
Yeah, I mean, there's a provision in B there, notwithstanding the foregoing. Could I see section 17 so I understand what this is talking about? Sorry.
Absolutely, we'll show you that.
Okay, we can go back up there. So yes, if they gave us written notice that they wanted to restrict the you know, like you said, use arms dealerships or something like that, then we would, yeah, we should be restricted by that. Yes.
Yeah. And if you go down to Article 4, if we can look at that, you see that CCM's liability is strictly limited so that it is not liable for losses incurred by Q1 as a result of its advice. Just have a read of that to yourself, maybe, because it's quite a long paragraph. Although I expect it's in rather standard form that you're relatively familiar with.
All limitations of liability tend to be detailed and long.
Yes.
Yeah.
And what is exactly your question, Mr. Harris?
I was just waiting for the witness to read it.
Yes, yeah.
Okay.
Professor Ernesto, I was trying to be fair. I know it's unusual for me, but I was trying. CCM was protected against claims for losses by Q1, except where the reason for those losses was fraud, gross negligence, or willful misconduct. Yes,
correct.
that's
Yes,
the next
correct.
line that just hasn't been highlighted yet.
Yes, yes. And our fraud, not
Yes,
any
fraud, gross negligence, or willful misconduct.
Yeah. By the investment manager, right?
Yes.
Okay.
And it actually goes further than that. If we go to Article 5, you can see that in addition to that exclusion of liability, if CCM is found liable for matters arising from its advice, it benefits from an indemnity from Q1. Yes?
Yes.
Now, just let's look quickly at Article 8. There we go. Independent contractor says for all purposes of this agreement, the investment manager, that's CCM, shall be an independent contractor and not an agent, employee, partner, or joint venture of the company,
right.
And shall, unless otherwise expressly authorized, have no authority to act for or to represent the company in any way. And that was an accurate description of the relationship between the parties created by this agreement, wasn't it?
Yes.
And finally, at Article 11, you can see at 11C, that this agreement may be terminated either by the company or CCM upon at least 30 days prior written notice or immediately in event of bankruptcy or insolvency of any party.
Yes.
See that?
Yes.
Now, the agreement with which the directors of 2014 one entered into with CCM is substantially very similar. That is at C0024. We don't need to go through that in the same level of detail, but in fairness to you, I'll just show it to you. And the date of the document is the 30th of May 2014.
Okay.
See that there. The parties are again VAM, which becomes CCM, yes?
Yep. Yes.
And 2014 one.
Yeah. And also the Carlisle GMS Investment Management.
Yes, that's the backup portfolio manager.
Yep. Yes.
Yeah. And if we go down to page 28, we'll see Richard Macmillan, the director.
Yes.
Was he a nominal director who just did whatever CCM told him?
I wouldn't classify it that way, no.
No. And let's just go up then to clause 1, please. What we'll see again is a whole list of services.
Yep.
In slightly different format, but if we can just scroll down and look at it, the sort of things that are there. Have you looked at this document at any time in the recent past?
No, I haven't. No.
All right. Well, perhaps I won't labour the point, but these are the same sorts of things, and it was another agreement which limited the scope of CCM's, or defined the scope of CCM's authority. Yes?
Yes.
And on
Mr. Harris, I mean, the witness has not actually seen this document for some time, and we are going very quickly through it. I think this matter is better for you to argue tomorrow or in your post-hearing brief or whatever, because I don't think that really the witness can add too much value to what is said there in the document.
I was merely...
Mr. Chairman, could I point out, please, that we've gone now an hour and 5 minutes. Of course, the tribunal had a few questions, but in terms of the time, my understanding was I had 15 minutes, he had an hour, and then I have redirect. So I think his time is close to being exceeded at this point, but I would just raise that for consideration.
I think Mr. Yohai might be operating under a misunderstanding. I have 2 hours to cross-examine Mr. Zuet.
I don't agree with that, since the witness time is total of 2 hours, and I have time for redirect. So my understanding is I had 15 minutes, you have an hour, and then I have my redirect.
Okay, we have 2 hours for the witness. There will be some questions from the tribunal. I'm sure there may be some questions from the redirect. So let's try to use the time as efficiently as possible, Mr. Harris. So, because if you want to show us tomorrow or whenever what these agreements say, that's perfect. But the witness cannot add really too much to that.
Yes, I mean.
So let's see if we should be trying to finish in an hour, then a little bit under an hour, if we want to stick to our schedule. So,
yes.
So take your time, and if you have any other really questions where Mr. Zuek can actually help us, that you are more than welcome to submit them.
Thank you. Well, let's move on to some questions about your trip to Morocco on the 11th of January 2016. And it was during that trip that you realized that Carlyle was unlikely ever to be paid by Samir, wasn't it?
That is correct.
And you discovered that, in fact, the accounts receivable which Samir had told you existed were in fact fictitious or grossly insufficient to compensate Carlyle, yes?
Yes, except I would say that what I discovered was that the accounts receivable that they had represented, they then represented to me, were basically taken by the Moroccan government.
And you discovered that Samir had been fraudulently misleading Carlyle about its ability and intention to pay, didn't you?
I would say yes to the first part. I don't know to the second part.
Well, I was actually reading part of your US affidavit from the 10th of November 2018,
okay,
where you said in terms that it was upon reviewing Samir's accounts receivable balances in mid-January 2016, Carlyle first discovered that in fact the accounts receivable referenced by Samir were either fictitious or grossly insufficient to compensate Carlyle for Samir's unauthorized use of the commodities, and that it had been fraudulently misleading Carlyle about its ability and intention to pay. Do you remember giving that evidence to the New York court?
Yes, I do.
Can we pull up R15, please? This is a document containing extracts from your deposition in the New York court proceedings.
Mm-hmm.
We go to page 7. of the PDF, beginning on line 18. Witness,
That's me.
it is my, you're the witness. It is
Yes.
my testimony that the commodities were stolen.
Yes.
And the questioner asks you, when were they stolen? And you say there was a fraud that was perpetrated over a period of time. And ultimately, you know, when we realized that the things that were being said to us, like, and told to us by representatives of Samir, including the general manager and CEO or CEO equivalent, including third parties who were supposedly independent third-party banks, that ultimately, you know, we came to realize that it was a fraud and our things were stolen.
Yes.
And then you just read on. I won't read it all out. Okay. That realization, sort of financial realization, came when I went to Morocco in early 2016, January 2016, to review the assets.
Yes.
And then you were asked, and when did Samir start stealing your commodities? And you say, well, I don't know exactly, but I would say, I don't know, I don't have the exact date. And you're asked if you have a rough idea of when that was. Mr. Yahai objects, but you answer, you say, yes, it was, I think it started happening before I was involved, so sometime before mid-August. And that was mid-August 2015 you were referring to there, wasn't it?
That is correct.
And if you go to page, if we go to page, the 10th page of this PDF, the next page, you can see your explanation of what you thought Samir was doing with the commodities that it had stolen from you. And so, you know, what I believe they were doing with the product that they were taking was they were refining it to the extent that it hadn't already been refined, and they were selling it into the Moroccan market, the refined product. Did you consent to that processing? No. Now, can we have a look then at paragraph 41 of your first witness statement in these proceedings, which was dated 31 July 2019, so about 7 months after your deposition in the US, which was at the end of 2018. Mm-hmm. And let's look at paragraph 41. You describe going to Morocco in the week of the 11th of January. Mm-hmm. You talk about the review of Samir's account receivable balances and all applicable invoices. Mm-hmm. But then the story changes completely from what you said in New York. Instead of saying, as you said in New York, we discovered that Samir had perpetrated this massive fraud on us and been lying to us and given us fictitious accounts receivable. Mm-hmm. Now you say the funds referenced by Samir had been drained as a result of the government's sweeping of Samir's accounts.
Yes.
And that Mr. S. Samar confirmed this, that, and the other.
Yes.
The government was preventing them from transferring the proceeds despite knowing that they were Carlyle's. And the funds we thought in Samir's account,
yes,
neither outstanding or available because the government had already taken $178 million.
Yes.
So just help me with this.
I don't think that I'm changing my story. Like I
well,
think that this whole
help me with this, Mr. Zach.
No witness
okay,
answer,
sure.
Please.
Yeah. So I mean, to be honest with you, like this was my last trip to Morocco. I had made numerous trips before this. I actually met with the Minister of Finance in December. You know, and this whole thing, you know, is very difficult to sort of get your head around, but it's my opinion that Samir was being instructed or pressured, whether directly or indirectly, by the government of Morocco to continue to refine products, which they did not have title to, which were our products, in order to provide refined products to the Moroccan market. Keeping in mind, Samir is the only refinery, or was the only refinery in Morocco. And while obviously they could be supplied for refined products from elsewhere, that wasn't something that could just happen overnight. And so Samir all along, when, there's documentation of this, I think in the September letter that we received from Samir, they basically state that they're being pressured by the government to continue to supply the market. When I say it's a fraud, the fraud was that Samir was telling us, oh, we have these receivables, I get there and find out that they don't actually have the receivables. I don't think that going into more detail here and saying that Mr. El-Samar or SMR was actually, told us that the government swept all of those receivables is inconsistent. I think it's, it's just an extension of the fraud. So, I mean, the fraud was that they were telling us that these receivables were available to pay us. The reality is they weren't, because the government took all the receivables.
Let me try and make this simple for you, Mr. Zueck.
Sure.
In New York, you said to the New York Supreme Court in a deposition on oath that you discovered that Carlyle had been the victim of a fraud by Samir, which was stealing your commodities.
Yes.
And you made no mention at all of the fact that they were doing this because of the government of Morocco, did you?
To my recollection, no.
And in these proceedings, in paragraph 41 that we're looking at on the screen now,
yes,
you say nothing at all about any fraud by Samir or that it's been stealing your commodities, do you?
In this particular paragraph, no.
No. What you say is that it's all the government. It's two different accounts of the same trip that you're supposed to be recalling. Yes?
I wouldn't classify it that way, no. I think, look, I'm saying the same thing. In the one instance, it's a fraud. In the other instance, it doesn't matter that it's a fraud. I was fraudulently being told by Samir that the receivables were there and that as soon as they could collect those receivables, they would be sent to me. Okay, when I show up there and I go to audit the receivables to ensure that they're there are no receivables, at which time they tell me the government has taken all the receivables. So yes, the fraud is that I was being told by Samir all along that they had the assets and the ability to pay me back. This is just telling me, I'm telling you my understanding of where all that money went. My understanding is all that money went to the government of Morocco.
Did you not think it was important to tell the New York court that your understanding was that Samir was selling these things and that the money that had gone from the account had gone because the government had taken it?
No, I didn't, because all I cared about in the insurance case was that our commodities were stolen. That's it. Like, they were stolen and we had insurance to cover the theft of the commodities. That's all the New York court case is about. It's not about the government of Samir or government of Morocco.
No, what the New York court case is about, and what you were doing, Mr. Zueck, is presenting a case to the New York court that said that Samir stole your commodities because that is what was the insured event. And in this tribunal, where it's not convenient to you to say that Samir stole the commodities, you say Morocco stole the commodities. That's the truth, isn't it?
No, it's not. No, it's not at all. In fact, I believe that Samir stole the commodities, and I believe that the government of Morocco seized all their assets. Like, I don't think those two things are in conflict with one another. Samir was a refinery. Samir was refining our oil without our permission, clearly in violation. In fact, they write out that it's in violation. And specifically in this case, as I said, the fraud was I was being told that they had receivables. I went there to audit the receivables because I was constantly being told that, this was going to happen. They were meeting with the tax office and we're going to resolve all their problems. They were going to have this done and the government was going to approve this or approve that. And then I go there and I find out they're not there. And so that, to me, is fraud. Somebody was lying to me, telling me that they had the receivables. When I found out the receivables weren't there, and this is receivables now, not commodities, receivables, it's very clear, or they made it very clear to me, that the receivables were collected by the government.
Let me put a couple of points to you. Step back. Let's try and clarify what your evidence actually is, because I'm not clear. The reason that Samir has brought this claim is because there was a theft of commodities by Samir. Yes?
The reason that Carlisle
has brought this claim.
Which claim are we talking about? Sorry.
This arbitration.
Okay.
Is because there was a theft of commodities by Samir. Is that right?
There was a. I honestly, I don't know the legal reasoning behind that. I don't know, why we're at the tribunal, to be honest with you. I'm just a witness. I don't have all the background. I'm not a lawyer, so I don't know all of the reasons behind that.
Mr. Harris,
I'll move to the next point.
Why don't we move to the next point? I think the issue has been sufficiently discussed, and we must move on. Do you have a lot more to go, Mr. Harris, or?
Not a lot, no. But I was operating on the understanding that I would have at least an hour and a half and probably an hour and 45 minutes.
Absolutely. Take your time. We have time. Take your time, and let's do things properly. But let's move to the next point.
Yeah, sure. All right, moving to the next point. Mr. Zuek, your testimony to this tribunal, which you expanded on and gave some new evidence on in your direct, is that the onshore feeder invested money in the master fund, and the master fund in turn invested that money in Q1. Yes?
That is correct, yes.
And I think your precise evidence is that the onshore feeder invested $184 million in the master fund, and the master fund in turn transferred 157 million of that to Q1. Have I understood that correctly?
Yes, that is correct.
Well, let's look at the evidence that you've provided for that assertion, which you expanded upon in your direct. You only rely on two documents for that assertion. They are C0032 and C0034. Let's look first at C0032. This is the audited financial statement of the onshore feeder.
Yes.
Yes?
Yes.
As at, for the year ended 31 December 2015.
Yes.
You see that?
Yes, I do.
Now, if we scroll down to page 7 of the PDF, which is page 4 of the internal, this is the page you rely on as being the evidence that there was a payment from the onshore feeder to the master fund of $184 million. And you can see that $184 million there. You see that?
Yes, I would say that's incorrect the way you've phrased that. This is the investment in Celadon Commodities at fair value. So that doesn't represent the dollars that were actually invested. So that's the fair value of the dollars that are invested as of that day.
Quite. What this doesn't show us, that's very fair of you, Mr. Zuek. What this doesn't show us is any payment going from the onshore feeder to the master fund at a particular date, does it?
It does not show that, no.
No. Let's look at C0034, which is the audited financial statement of the master fund, Celadon Commodities Limited. Do you see that?
I do, yes.
And this for the same year end, 31 December 2015.
Yes.
And if we go down to page 9 of the PDF, which is internal page 6, again, we'll see page 9. We'll see the page that you rely on in your evidence for the $157 million figure.
Yes.
And would I be right to understand that you're going to make the same point here, that this shows the fair value of the master fund's investment in Q1 as at the 31st of December 2015?
Yes, and if you look over to the left, you see the cost at 180 million. Under the total investment investee funds, cost 180 million. So that would be the dollar figure that was invested in.
Right. I had rather assumed that that was grossing up the 87.87%. Is that wrong?
I haven't studied this. I would have to look at that.
You don't say this in your witness statement, though, do you? Well, you don't refer to that 180 million in your witness statement.
I don't, but here's the thing that's slightly different between the investment from Celadon Fund Limited to the master fund. So we had other investment activity going on at the master fund level. That investment was around for a long time. I don't remember the exact date that we started Celadon or when Maryland invested into Celadon. So there you had a lot of market movements. In the case of this activity, I think the market movements are smaller, but I don't, am I allowed to use a calculator or no? I don't know what I'm allowed to do or not do here.
You're on mute, Professor Armesto. So.
That's because when I type, no, I have done the calculations. I think it is, if you go from 87 to 100%, my calculation is 183 million.
Okay. Right. So I'm not, but basically these numbers should be closer to the cost, not market value. That would be my testimony.
But what it doesn't show, again, it doesn't show any particular payment by the master fund to Q1 on any particular date, does it?
No, this is a statement of financial condition as of 12/31. As part of the audit that Ernst & Young did, is they went back and audited the transactions throughout the year that made up these positions. That's part of what auditors do.
Well, Mr. Zurek, I don't have any further questions for you at this point. Thank you.
Thank you.
Thank you. Thank you very much, Mr. Harris. So let us do the following. Let us make a short break because we have now been going on for 2 hours. It is now 16:29 here in Europe. Shall we come back at 16:35? And so we give everyone a little bit of time. And Mr. Yochai, you have also some time to prepare your redirect. 16:35, we are back. Let us wait a little bit for the secretary to confirm that everyone is back.
I can confirm that everyone's back.
Very good. So we resume the hearing, and Mr. Yochai, you have the floor.
Okay, thank you. Let me see first if I can go over quickly the payment issue that was discussed earlier. If you could put up, please, Kim, C46. And if you could blow up the first section of this letter, please, from Mr. Zurek. Mr. Zurek, I'd ask you to take a look at this letter. And if you could explain for the panel, please, your understanding of what the function of this letter was.
Sure, sorry. So this is basically a letter of direction where Samir Sorry, can you take the call out down? I'm just.
Sure, so he can read the whole thing.
Yeah. Right, okay. Yeah, so this was a letter of direction that basically asked us to pay the supplier directly for commodity, at which time, you know, as I mentioned before, Samir would receive title and then effectively flash title that over to us.
So rather than paying Samir directly, you would pay the supplier at Samir's direction, correct?
Correct.
Okay, and on the next page, if you look at that, that letter was signed by both you and Samir, correct?
Correct.
Okay. We had some questions on the investment management agreement, CC 47. If you could put that up quickly. Okay, if we could return, please, to a portion of the agreement in paragraph 1 to blow up for Mr. Zewik. You went over a lot of this paragraph on cross, but not all of it. Mr. Zewik, could I ask you to give us your understanding of this agreement where it states that the investment manager may determine in its sole discretion what that means?
Sure. It means we had complete authority over what to invest or not invest in, and we had sole discretion to do that without subject to any review by the directors or by any other party.
Okay, and 2 lines down again where it says the investment manager shall act as the sole investment manager.
Yes.
You see that? What was your understanding of that?
That there were no other investment managers and nobody else with the authority to make investments on behalf of the fund.
On cross, you were asked some questions about the role of the directors in the various entities. Could you elaborate on the role of the directors versus the role of CCM?
Sure. The director's role was basically similar to the general partner's role in the limited partnership agreements. Their role, their primary purpose was to appoint the investment manager to act on behalf of the fund. The directors had no day-to-day interaction or authority over the portfolios.
Okay, let's go on to the subject of the New York litigation. You were asked some questions relating to consent.
Yes.
Can you explain, please, did CCM or any of its vehicles ever consent to the refining of the commodities without payment?
No.
Okay. Now, if we could put up, please, CZ03. Do you recognize this document?
Yeah, this is the storage agreement between Samir and the initial VM party, which was the 2014-1. No.
And if we could turn to section 3B, please. Mr. Zewik, what is your understanding of this portion of the agreement?
This basically lays out that the custodian, or Samir in this case, cannot use the commodities, period, unless we consent to have them, allow them to.
Okay, and if we could look at section 4A, please.
Yes.
Could you please give the panel your understanding of this provision?
This is, consistent with what I just said. Samir was not allowed to use our commodities without our prior written consent.
Now, did you ever tell Samir that?
Yes, multiple occasions.
Okay, if we could call up, please, CZ 15. And if we could, well, first, do you recognize this document?
I do. This is a letter to the general manager of the Samir refinery.
Okay, and if we could blow up the second paragraph of your letter to Samir. Could you explain why you wrote to Samir over the past several weeks, Samir sold and disposed of certain commodities without obtaining VAM's prior consent in violation of Section 3?
Sure. We had discovered through tank reports that the commodities were being sold, commodities that we owned were being sold, were being refined and then being sold, and we had never consented to any of those actions.
Okay, and what did Samir say with respect to this point?
Samir's response was that they understood that they were violating the agreement, but that they were being pressured by the government of Morocco to continue to refine oil and provide refined products to the marketplace.
Okay, and if we could look at CZ 17 on this point, which is the forbearance agreement.
Yes.
Okay, do you recognize this?
I do. This was an agreement that we entered into with Samir.
Okay, and if you could blow up the third whereas clause, please. Could you explain why this was in the forbearance agreement?
Yes, this was basically putting Samir, or having Samir, put in writing that what they had been representing to us verbally, that the government of the Kingdom of Morocco had frozen their bank accounts, prevented them, from making any payments to us, and were basically forcing them to continue to refine and sell the commodities that we owned.
Who wanted this provision in the agreement, if you know?
Sure. Actually, it was the Mr. Baumer, the Samir refinery wanted this in the provision, because they were the ones that were insisting that this is what was causing them to continue to breach the agreement.
Okay, and then finally on this point, if we could put up CZ 26. Do you recognize this document?
Yes, I do. This was a letter that I wrote to Mr. Bassad, who was the Minister of Finance for Morocco, which was just a follow-up to the meeting that we had directly with him as it related to what was going on with Samir the previous week.
Okay, and if you could blow up the part, please, that says without Carlisle's consent, been improperly removed without Carlisle's consent.
Sure.
Why did you write this?
Just again to make it very clear to the Kingdom of Morocco that this was our oil, that we had title to it, and our refined products as well, and that the disposition of that without our consent and without payment was unacceptable.
Okay, we had some, moving off of that, we had a question about CZ1, the letter from the Moroccan Finance Ministry.
Yes.
If you could just look quickly at the first paragraph.
Yep.
It states in the letter mentioned in the reference line, you inform the office that changes that your company intends to enter an agreement with the U.S. company Vermilion Asset Management, VAM.
Yes.
Do you see that?
Yes, I do.
What did you understand that to mean?
That that Samir had presented sort of the way that we looked at the relationship. They looked at it the same way. Their relationship wasn't with one of the different funds or entities that we were managing, but the relationship was between Vermilion and Samir.
Okay. If we could put up, please, CZ34, or maybe C34. It was the accounting document that we were looking at. Okay, we discussed this on your cross, right?
Yes.
Okay, and if you could go to the page we were looking at before with the on cross, please. Which I'll try to help you. Well, first of all, if we could go to page, numbered page 6. 1, 2, 3, 4, 5, 6. It's not yet. It's 9 of the PDF, I believe. Yes. Yes.
Okay.
And just looking at the top line again.
Yes.
Okay, putting aside the issue of fair value,
Sure.
Mr. Zurich, and exactly how much fair value is, could you explain your understanding about whether the master funds were in fact deposited into VMF Q1?
Yes, they were.
Okay, and similarly, it's true, is it not, that the onshore feeder funds were deposited into the master fund, correct?
That's correct. And in both cases, in exchange for participating shares.
Okay, so does the issue of fair value detract at all from those core points, regardless of exactly whether it's fair valued or valued otherwise?
No, no.
Okay, thank you. One last point on the issue of the swaps. If we could have demonstrative 3 that the claimant that the respondent put up in its opening. And just looking at line items 14, 15, and 16.
Yes.
Could you explain why it would say no information is provided in the columns of letter of credit, payment for LC, et cetera?
There wouldn't be any reason, like I can't see any reason for that. There wouldn't be a letter of credit in place, and there wouldn't be any payment for the letter of credit because they wouldn't apply in that case. And in fact, in the sleeve transaction, they wouldn't apply in that case as well. So that would be the reason why.
And just to be clear,
kind of not applicable in this.
And just to be clear, that's because Q1 previously purchased oil.
Correct.
And then swapped that oil for refined products in these swap transactions, correct?
That's correct. That's correct.
Okay. I have no further questions, Mr. Chairman.
Understood this. It's again, can you repeat your question, Mr. Yohai, and the answer of Mr. Zwick regarding the swaps?
Yes. The last question that I asked was, and that's because Q1 previously purchased crude oil in the 103 and 106 transactions, and then in these swaps, swap that crude oil for an equivalent value of refined products. Isn't that right, Mr. Zwick?
Yes.
Which sounds rather like a leading question.
Well, I'm just trying to clarify the point. It's not really, in other words, I think we all understand at this point how that worked. I'm just making sure that the panel does, okay? If you have any further question, Mr. Chairman, please ask. This is the time.
Can I, Mr. Harris, I will give you the floor back. But before we lose this issue about the swaps, could I kindly ask that someone in your team, Mr. Yohai, puts up counter memorial on jurisdiction, page 55. You remember we discussed that, you and me, we discussed that yesterday.
I do. I remember we were discussing it and that it did not have the swaps on it.
Exactly. And I want to understand that.
Yes.
So can I, Mr. Zuek,
Yes.
this document, which you see there, page 55, was prepared by Carlyle's counsel.
Yes.
Okay, so it is an annex to one of the submissions of the counsel to Carlyle. And it explains the source of funding for the letters of credit. You see that?
Yes.
Source of funding for LLC.
Yes.
And you have a summary at the bottom.
Yes.
And exactly. And then if we can go to the bottom, you will see Q1 total 68, 69 million, a bit further up. Sorry for that. The Q1 total, that's it. 69 million. You see that?
Yes.
And I was putting the question to counsel yesterday because this number does not fit the number we saw in the accounts.
Yes.
You remember that in the accounts, we saw numbers which were in the hundreds.
Yes.
They started and eventually it was like 136 million. You remember that?
Correct, yes.
And so could you explain to me why this number does not coincide with the 136 number?
Sure. The difference is the swap transactions. So they were roughly 65 to $70 million as well, I believe. And so the original transactions, were closed out. So now you had the open swap transactions. So this is only dealing with the letters of credit side of things. But those swaps, like once it was swapped out, the letter of credit no longer applied. All we were doing is swapping oil for refined products.
Okay, let me explain it in a more lawyerly fashion.
Okay.
What I understood is that there were some other transactions, which were Samir 1003 and some other, two others.
Yes.
1006, yes.
Can you repeat the numbers, Mr. Johan?
1003 and 1006.
1003 and 1006, which
Correct.
were not there, which are not in this list.
Correct.
That's correct, because they weren't open any longer at the time. So those were closed out, and then basically what the swap meant was that we closed out the old transaction and opened up a new transaction. So the refined products replaced that, and that was about roughly 70 million in value.
Okay, so let me try to put this. If we put in there Samir 1003 and Samir 1006,
it should add up
which
to
had been where there had been funding for the LC.
Yes.
And that funding had been done by whom? By Q1. They had been funded by Q1.
Yes.
And then what happened is these two LCs referred to a certain amount of tons of crude oil, which were somewhere in the premises of Samir.
Correct.
And then through the swap, they were converted in the equivalent amount of refined products.
That's correct.
But here, so if I want to reconcile this number with the account number, what I would have to do is that in page 55, I would have to add Zamir 1003 and Zamir 1106, and that would then make these figures correspond to the figure in the accounts.
That's correct.
Thank you. Thank you. So, Mr. Harris, do you have any follow-up question?
I'm just reflecting.
Which comes out of either the redirect or my own question.
The problem I have, I can't really ask you questions because we don't have any of the documents on the swap transactions. So you can't do the exercise that you've just talked about because you've got no evidence as to what the amounts were or where they came from.
Well, we have the evidence of Mr. Suek.
But also,
Well,
Mr. Harris, Mr. Chair, you have the swapped closeouts in the documents that we submitted. They're in the RW documents, so you do have them. I can give you the numbers, but you have them. 51, 52, 53. RW 51, 52, 53.
What we don't have is 1003 and 1006 closeouts.
Okay, but let us not.
Sorry to argue with you, but that is 51, RW 51 in the record.
Gentlemen, this is not for now to discuss.
Understood.
Do you have any further question for Mr. Suek? No. Very good. Professor Grijera Naon, do you have any question for Mr. Suek?
Nothing on my side.
Mr. Wordsworth, do you have any question for our witness?
No, thank you.
Mr. Suek, I have just one small confirmation, two or three confirmations for you.
Okay.
The Carlyle Group is a group parent of Celadon Partners LLC.
That's correct. The majority, they were the majority owner. I think they owned something like north of 85%. I don't know the exact, I don't recall the exact numbers.
And the Celadon Partners LLC and all the companies which depended from Celadon Partners LLC, they would be consolidated in the accounts of Carlyle.
Yes, that would be correct. Yes.
But let me ask you two questions. The portfolio, which in Q1, and the portfolio in Celadon Commodities Ltd, the master fund.
Yes.
These investments, would they appear on the financial statements of Carlyle Group or not?
They wouldn't appear as individual line items. They would appear as their investment in the case of Carlisle, the Celadon Commodities Fund Limited, which is the offshore feeder fund.
No, my question is, look at this Maryland pension scheme, which had 99.97% of Celadon. It was a limited partner in Celadon Commodities.
Yes.
And then do these limited partners, do these amounts which are invested on behalf of clients,
yes,
do they show are they consolidated into the financial statements of the group?
I don't know the answer to that. Yeah, I don't know the answer to that.
Let me ask, but I think you will know the answer to my next question, is the notes which were issued by 2014 and 2015,
yes,
these do not appear on the financial statements of Carlyle Group or of Celadon Partners.
That's correct.
That's correct. Thank you. Thank you very much. I think that's all my questions to you. And I thank you, Mr. Suek, for having made the effort of being here with us and having helped us to better understand the...
May I have a follow-up question on your...
Oh, of course, of course. Professor Grijera Naon, you were smiling too early, Mr. Suek.
Sorry,
almost off the hook. Okay. Sorry.
I'm sorry for this. But I have a similar question regarding 2141 Limited and 20141 Limited and 2015 Limited.
Yes.
how do they integrate in the general Carlyle Group context? Who owns them?
So
I know that you have said something about that, but I want to better understand it, because on one hand, I think that the point that is being made to us is that CCM has some de facto control on these companies, but I would like to know if there is anything else.
Sure. I apologize because I don't, because I wasn't really a partner of Carlyle, I don't know all of the consolidation rules from US, sort of financial reporting perspective. I believe, I thought that there was something to do with consolidation, but I really don't remember. It sounds familiar.
Well, but my question doesn't relate to consolidation.
Okay.
I understand that you were involved in the creation of these companies.
Yes. So
consolidation or not.
Okay. Yeah, no. I mean, those companies were designed, were developed by us. It was a structure that we developed that allowed for the issuance of securities, bonds in this case, from the entity. Those bonds, as well as the subordinate bonds, or they may have been referred to as the equity participation, were issued. That money then came into the entity, and then that money within the entity was invested by CCM into these various types of transactions.
So if I read you correctly, the element of control would just be contractual. The fact that CCM was running in one way or another the business of these two companies.
Yeah, that's correct. That's our control was, through the investment management agreements.
Okay. Thank you very much.
Okay.
Thank you, Mr. Suek. This is now final. Thank you very much for your effort, and you are released from any obligation to the tribunal. Thank you very much for your effort.
Thank you very much. Nice to meet you all. Bye-bye.
Goodbye. Thank you, Mr. Suek. Have a nice day in New York.
I'm in Texas.
Oh, in Texas. Well, then probably better weather in Texas than in New York.
Okay.
Very good.
Bye-bye.
We will now break, and we are reasonably within time. And we will now break for, I think we said a quarter of an hour, no? So it's 17:25. We will then come back, or 17:25. Very good. Thank you very much.
Professor Armesto, I think everyone is back.
Very good. And we have, I see there, Mr. Taylor. Good morning or good afternoon to you, wherever you are. Where are you?
I'm in London, Mr. President. Good afternoon to you as well.
Good afternoon to you. Mr. Taylor, you are here as an expert, and this being an exit arbitration, the first thing we have to do is we have to take your oath. So the secretary will put up the text of your declaration, and can I kindly ask you that you raise your right hand and that you take your oath?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Thank you very much, Mr. Taylor. So I think it's Mr. Shalfoun. What would be the Shalfoun?
It isn't an originally English name, so really whatever. But Shalfoun is probably the one I use.
Mr. Shalfoun, who is you have him so that I can give you some explanations, Mr. Taylor. You have Mr. Shalfoun, who is counsel to the Kingdom of Morocco. You have Mr. Yohai and Mr. Ordway, who are counsel to claimant. You have Mr. Wordsworth QC, who is one of the co-arbitrators. You have Professor Grijera Naon, and you have Ms. Rosenberg, who is the secretary, and Ms. Seara Cardoso, who is the assistant to the tribunal, so that you have a view of how it is in the room. And I will give the floor now to Mr. Chalfoun to introduce the expert.
Thank you, Mr. President. Good afternoon, Mr. Taylor.
Good afternoon.
Could you please state your full name for the record?
My full name is Travis Alexander Penrose Taylor.
And you have given one expert report in this arbitration alongside your colleague, Mr. Dagia, is that correct?
That is correct.
And you should have before you one redacted and one unredacted printed version of your expert report, which I understand have no annotations. Is that correct?
That's correct.
And I also understand that you should have before you a copy of a PowerPoint presentation with you, again, without any annotations.
Correct.
Is that correct? Do you have any corrections to make to your expert report?
No, I don't.
Then may I please invite you to present your presentation to the tribunal. Thank you.
Thank you.
Mr. Taylor, if you have a presentation, we must give it a number. So it will be H5?
Correct.
H5. And Mr. Taylor, you have the floor.
Thank you. Can you see that?
Yes, yes, we can. Thank you very much.
Is that on full screen or is that?
Oh, you have on the left, you have all the different slides.
Yeah. I think I was told F5. But...
Yes, and if you as well go to slideshow at the top.
Yeah.
And then say from beginning, which is to the far left.
Perfect. Thank you. So yes, good morning, good afternoon to everyone. I will talk to you today. I'll cover my instructions. I'll also talk about whether CCM had control of Q1 2014-1 and 2015-1 from an accounting perspective. I'll also provide an overview of commodity repurchase or repo transactions. So moving on to section 1, my instructions. And now I'm on page or slide 4. And I think the most important thing just to cover off is that my report of the 7th of September 2020 was co-authored with my colleague, Brian De Geer. And that is because we have different specialisms. So I am a qualified accountant specializing in providing reports on damages and quantum of loss assessments. Mr. De Geer has significant investment advisory experience, having worked as a portfolio manager for prominent asset management companies. And we made it clear in our report at paragraph 14 that we would take specific responsibility for those particular sections within our report. And that's important because Mr. De Geer has not been called to provide evidence in this hearing. And I have relied upon some of Mr. De Geer's analysis. So just to cover off what our instructions were, Mr. De Geer was firstly asked to provide an overview of the role of an investment advisor or investment manager, and to review and comment upon the claimant's organizational and CMIR deal structure, including contractual and economic arrangements. I was asked to, well, fairly narrow remit actually, I was asked to address the definition and relevance of control under International Financial Reporting Standards, IFRS, and US generally accepted accounting principles known as US GAAP, and when assessing whether a fund manager should consolidate funds it manages in its balance sheet. And secondly, whether the arrangements in place by Carlyle would constitute control from an accounting standpoint. So the key question here was was CCM exercising control over the underlying investee funds from an accounting perspective? The second requirement which I had to address was providing commentary on Mr. Walk's second report of 22nd of June 2020. And the key question that was related to my expertise was, were the arrangements in place between the claimants and SME representative of repo transactions or repo loans? So turning to section 2, did CCM control the investee funds from an accounting perspective? And I'm now on slide 6 for the record. So, control is a very important concept and is the basis really for determining which entities are consolidated for accounting purposes. So once you've established whether control exists, then you need to consolidate the financial statements, and that means essentially aggregating the revenues, the expenses, assets and liabilities for the various entities which you control, and presenting them as one set of financial statements. And you would also eliminate the transactions between the entities that you control as well. So it's a critical concept for providing confidence in capital markets by providing comparable, transparent and reliable information. Control mostly arises through holding more than 50% of the voting rights, but can also exist below this level, usually with contractual relationships. The two main accounting standards, IFRS and US GAAP, provide guidance on the concept of control. Usually similar conclusions are reached, not always, but usually similar conclusions are reached under both standards as to whether control exists. The focus of my analysis was on IFRS rather than US GAAP. IFRS has been adopted by 120 countries globally. And I think from my perspective, IFRS 10, which is a relevant standard under IFRS dealing with control, has a lot of helpful guidance on the treatment of control for fund managers, as it applies to fund managers. And I believe the guidance set out in the accounting standards is instructive for the purposes of assessing control generally. I think they're designed to try and reflect the economic reality. Now, whether it's...
Excuse me 1 second. I'm not able to see that on, at least on my screen, the part that you're referencing. Is there a way of magnifying that?
I don't know. I can see it on my screen. I'm sorry, Mr. Ordway.
This is Scott from Trial Graphics. I have an idea. I believe without too much delay, Mr. Travis, you're sharing the screen incorrectly. So if you stop the share and then you go to share again, and then make sure you select your presentation versus the what I'll call the back end of your presentation.
Okay.
Perfect.
Is that better?
Yes, much better. Thank you.
Okay. Yes. So as I said, the guidance set out in the accounting standards is instructive for the purpose of assessing control generally, and they're designed, and I think it's they do try and reflect the economic reality. Now, whether that's suitable from a legal perspective for the purposes of this arbitration, that is a matter for the tribunal. Moving on to slide 7, hopefully you can see that all okay. So as I mentioned, IFRS 10 is the relevant standard in IFRS, which deals with the issue of control. And what that says is that control is established when all 3 of the following elements are sufficiently satisfied, and it's important, sufficiently satisfied. So the first pillar, if you like, is power over the investee. And that, as I said before, usually arises through voting rights, and usually more than 50%. It also relates to the ability to appoint and remove key personnel. The second pillar is the exposure or rights to variable returns from involvement with the investee, and that often arises due to dividends or remuneration arrangements with the investee. And the final pillar is the ability to use its power, or the ability for the investor to use its power over the investee to affect returns. And that looks at things like the scope of its authority, the rights held by other parties to potentially remove the investor, remuneration arrangements, and also exposure to variability from other interests, so direct interest, for example. And these elements are also assessed to determine if a fund manager is acting as a principal where control exists, or an agent where no control exists. And specifically, the guidance looks at the last pillar when looking at fund managers and control as well. So we'll come on to those four factors in the next slide. So as of the 7th of October 2015, the CCM did not control Q1 2014-1 or 2015-1 through more than 50% of the voting rights. I think it's common ground that there was no direct interest in the investee funds. So we have to look to see whether there's other indicators of control. So the first thing you would look at is the scope of CCM's decision-making authority. So we would look at, the portfolio management agreement in place and the investment management agreement. So you'd look at, the activities permitted by that agreement and by law, the extent of its discretion, and it would also look at, things like I listened to Mr. Zuak's evidence, for example, and it's noted that CCM had involvement in the investee's design and setting that up. That's all taken into account. The second factor is the rights held by other parties to remove CCM. So substantive removal or other rights may indicate that the decision maker is an agent. Then we'd also look at CCM's remuneration. The greater the magnitude and variability of the decision maker's remuneration relative to the investee's overall expected returns, the more likely the decision maker is a principal. And then finally, we look at CCM's exposure to variability of returns from other interests in the investee. And this is a really important element for the current matter at hand. Holding other interests in an investee in addition to its management contract indicates that the decision maker may be a principal. In evaluating its exposure to variability of returns, the decision maker considers all its exposures. For example, fee based on performance of a managed fund plus direct holdings in that fund. So moving on to slide 9, and this was my conclusion. And based on the accounting guidance, it seems clear that CCM acted as an agent of the investee funds to which certain powers were delegated, but there was no ownership or control of these entities. And we'll discuss why over the next 2 slides. So certainly from the first, if we remember the 4 factors that we need to consider for a fund manager and control. And the first is the scope of the decision-making authority. And the claimants state that CCM fully controlled the investment decisions by, amongst other things, determining the specific collateral to be purchased, managing payments, engaging in hedging transactions, and exercising all the entity's rights of ownership with respect to the commodities. And that's borne out by the portfolio management agreement. It's borne out by Mr. Zuak's testimony and some of the openings that I watched with interest yesterday, some of the presentations there. But essentially these are service contracts that state that CCM's relationships were typically those of an independent contractor and not those of a partner or joint venturer. In terms of the removal process, CCM's role for the notes entities could be terminated for cause on 20 days notice by a supermajority of the senior and subordinated note holders. With respect to Q1, there was a mutual provision permitting termination on 30 days notice. In terms of exposure to, in terms of remuneration, CCM earned annual management fees of between 0.5 to 1% per annum on net asset values. I think it's higher for the notes entities at 1%, but there was no performance fees for the notes entities. And for Q1, there was performance fee of 15 to 20% for outperformance over a reference commodity index. So that's dealt with 3 of the factors, and then we have to look at exposure to variability of returns from other interests, and that's dealt with on this slide here. As I mentioned, IFRS 10 explains that holding other interests beyond remuneration that increase overall exposure to variable returns is indicative of a principal or control relationship. But a direct interest of less than 10% is unlikely to result in being a principal, even if other indicators such as lack of substantive removal rights suggest otherwise. CCM had no proprietary trading accounts and therefore had no risk associated with any direct investments. The Carlyle entities as a whole had a very small direct interest and participation, and CCM was indemnified against any losses. So the illustrative guidance in IFRS 10 is conclusive here that CCM would not be classified as having control. And that conclusion is consistent with US GAAP, in my view. If you look at ASC 810, the fact that CCM has no direct interest means that the CCM is not absorbing a significant amount of losses or enjoying a significant amount of profit, so it would fail the control tests under ASC 810 as well. So taking into account all of the factors we need to take into account, being the decision-making authority, the removal provisions, remuneration, and the exposure to variability of different returns, the conclusion is, as I stated before, that CCM is acting as an agent and has no control. Moving on to section 3, and this is the overview of the commodity repurchase or repo transactions. And in Mr. Walk's second report, he concluded that the arrangements in place, he said that, I've concluded that these structured commodity transactions from a financial and accounting perspective are clearly complex hedged commodity and derivatives transactions, not simple repurchase agreements. Moving on to slide 14. So the question is, what is a commodity repo transaction? And this definition comes from Kimura Capital, which is a London-based asset management company specializing in commodity trade finance and alternative financing arrangements. And they say that a commodity repo transaction is a transaction where a customer, so in this case Samir, sells a commodity to the lender, Carlyle Group, and simultaneously agrees to buy it back at a fixed or determinable future date for a prearranged price or against a determinable formula. The lender, so Carlyle Group, then has title over the commodity for the period of the facility and exchanges the commodity for cash at maturity. In his second report, Mr. Walks does not acknowledge the prevalence or even the existence of commodity repurchase agreements. His focus is on securities repurchase agreements, and securities repurchase agreements are common in the banking world. They're used for overnight lending between banks. They're used by the Federal Reserve to create liquidity. They often involve standardized agreements. There's an auction process to set prices. So it's no surprise that Mr. Walk could find no characteristics in common with the arrangements between the claimants and Samir, because he was focusing on securities repurchase agreements rather than commodity repurchase agreements, which are obviously more relevant in this case. So now that we know what a commodity repo transaction looks like, let's look at what actually happened between the claimants and Samir. And this analysis was put together by Mr. De Geer, but I think it's helpful to just walk through the chronology of the transaction, I guess. And it starts with Q1 of 2014. One would arrange for purchase of crude on behalf of Samir, posted letter of credit in favor of the supplier. The agreement treats Samir.
May I just interrupt for a second? Am I correct that what you're referring to here is derived from Mr. De Geer's report and not from yours?
Well, we co-authored the report. Mr. De Geer, as I said at the start, analysed the structure and the commercial arrangements between the claimants and Samir. So I'm drawing upon his analysis.
Well, I understand that. I'm afraid I would object to the extent that you are introducing into your presentation parts of what were in Mr. De Geer's presentation, because it was our expectation that you would be addressing that which you were specifically responsible for, which were those two areas that you identified initially. So we would object to this, and I defer to the tribunal in this regard, but this was not what we would have expected to be part of the presentation, since it draws from a part of the report in the Versant report that Mr. Taylor has admitted that he was not responsible for.
Let me ask you one question, Mr. Ordway. Was it you who asked that Mr. De Geer is not here? Why is Mr. De Geer not here?
Well, it was not necessary from our standpoint for Mr. De Geer to be present, because we thought that all of the issues that Mr. De Geer raised could be addressed. There were legal issues that we thought were not necessary for having him present. So that's the reason. And the same is true, for example, for Mr. Travers, who is a Cayman Islands attorney and really did not have, in our view, comments that had any relevance to this case. All I'm saying is that in calling this witness, we had anticipated that he would deal with those exclusive areas. And we simply have an objection to his introducing the subject that he has acknowledged he was not directly responsible for. Having said that, if the tribunal wants to hear what he has to say in this regard, obviously it's free to direct him to do that. We're simply registering our objection because it was not our expectation, any more than of course we would expect Mr. Walk to testify about areas that were not within his report.
But Mr. Ordway, so your expectation was that Mr. Taylor would just speak on which items?
Well, on the two items that he had identified in his report that he was responsible for, namely, and he's actually identified them in the first part of his presentation, and that is the definition and relevance of control under IFRS and US GAAP, and commentary on Mr. Rory Walk's second report. And he identified those areas, but he is now, it appears, going into a review of the transactions, which was really not other than the so-called repurchase transactions issue, but this was not part of his presentation in his report and what he was responsible for.
Okay.
So, I mean, actually, in other words, as we all know, each party has the right to call his own witness, and frankly, respondent had the right to call Mr. De Geer if they had wanted to, and if they had called him, then we would be in a position to examine Mr. De Geer, and that would be fine. But we did not feel it at all necessary to call him, and but we did want to call Mr. Taylor, and we're just a little surprised that he is now introducing evidence that's not evidence we expected him to be addressed.
But my question is, I see your point, but when you called Mr. Taylor, did you draw attention to the fact that you only expected him to depose on these two issues or not? Because very frequently, as you know, Mr. Otway, you find that you have had 2 or 3 experts, and I have seen the other point, that the parties insist that only one of them should speak, that they should not all of them speak, or that they should. Normally, the objections is that one of the experts should be the only one to speak. So my only point is, did you draw the attention of Mr. Taylor that he should only speak on these 2 issues, or that you only wanted him to speak on these 2 issues?
No, I did not understand the procedural order to require us to make that clear, because when normally you call a witness, you expect the witness to be addressing those issues which were part of his report. That's my only point. Again, if the tribunal wishes to allow it and wishes to hear it, obviously we are at the mercy of the tribunal. I am just pointing out that this was not our expectation, and that we register our objection, but it is the tribunal's decision, obviously.
Yes, thank you, Mr. Otway. No, my point is, it is normal that one of the experts makes the presentation for the whole work, although some of his colleagues have worked in certain parts. And if you have not really drawn the attention of respondent and of Mr. Taylor that you only really wanted him to speak, to depose on these 2 issues, and normally one would expect an expert to cover those issues which are even in his report, even if in parts which have been prepared by one of his colleagues. So if you have not actually drawn the attention to that, I think it is now the proper thing is to let Mr. Taylor finalize. And if you don't want to cross-examine him on these issues, that's perfectly okay.
I understand. Thank you, Mr. President, and we accept your ruling on this.
Thank you, Mr. Otway. Mr. Taylor, you have the floor.
Thank you. And just to put my position as to how I envisaged this would happen. I mean, I'm asked to comment upon whether the arrangements in place between the claimants and Samir represented a repurchase loan arrangement, repurchase agreement. So to the extent that I need to reach a conclusion on that, I obviously need to review the underlying transactions and that were in place between the claimants and Samir, and that analysis was undertaken by Mr. De Geer, and I have not looked at that in detail. What I say at paragraph 156 of our report is that we describe the claimant's organisational structure insofar as it relates to the commodity transactions entered into with Samir in section 4, and we do not repeat that analysis here, but in the following subsection we discuss Mr. Walk's interpretation of the claimant's transactions with Samir. So what we're doing,
Mr. Taylor, let's get into
sure.
A little time. Let's get
understood.
Understood. I want to know more about what you have to tell to us. So
understood. So okay. So my understanding of the arrangement to Q1 2014-1 would arrange purchase of the crude on behalf of Samir, post a letter of credit in favour of the supplier. The agreement treated Samir as a purchaser, but 2014-1 always paid. The oil company delivered the oil to Samir, and Samir paid a 6% deposit plus any prepayments to Q1, who then held title to the oil. Q1 would enter into sleeve transactions with 2014-1 and 15-1 for resale of the oil that Q1 purchased on behalf of Samir. And then there were call option arrangements. Samir had a call option arrangements. Samir had a call option Q1 had a put option over the right, but not the obligation to sell the crude to Samir within a 90 to 120 day window. The repurchase price was paid minus the original 6% discount plus interest, and then the notes entities would enter into hedges for exposure to decreasing oil prices by entering into exchange traded futures contracts. And then Samir also needed to pay margins on top on any drop in the oil price below the purchase price. So moving on to the
let me ask you one question,
Sure.
because that is to me an important question. Can you go back? The repurchase price. So the repurchase price was isolated from any movement in the spot price of crude.
Well, again, this is just my understanding based on Mr. De Geer's analysis, and he covers this at, I believe, footnote 76 of our report. So my understanding was that the price didn't move. That was Mr. De Geer's conclusion.
Thank you.
So moving on to slide 16, and this you'll recall on the right-hand box is the definition of a commodity repurchase transaction as provided by Kimura Capital. And Kimura Capital in their paper have also put in this graphic, which essentially depicts an overview of a repo transaction. And we can see here that the steps involved repo terms agreed, the timing, the amount, storage arrangements, purchase and sale prices determined either fixed or by a formula, goods delivered up, and then transfers between the lender and the customer. And you can also see that it also envisages the lender has flexibility to structure via fixed terms or through call or put options. And so what is the purpose of the repo transaction? You can see in the top right of this box, it's to enable a customer to temporarily sell stock for cash with a buyback agreement so as to improve cash flow without drawing on credit lines. Now, Mr. President, the next couple of the next slides are protected information, I believe. I've been advised. So in conclusion, the arrangements in place between the claimants and Samir were clearly typical of a commodity repurchase or repo transaction. And that concludes my presentation. Thank you.
Thank you, Mr. Taylor. Is there, very good. Is there on Mr. Chalfoun, do you have any follow-up question?
No, I can yield to the claimants.
Very good. So we give to Mr. Yohai or Mr. Ortway the floor.
Thank you very much, Mr. President. So, Mr. Taylor, as you indicated initially in the beginning of your presentation, the only two sections of the report that you were expressly responsible for were those addressing the definition of control and under IFRS and US GAAP, and secondly, providing commentary on Mr. Rory Walk's second report. That's correct. I think you've indicated that, so that is a correct statement. Is it not?
Well, in relation to Mr. Walk's second report, I think it was in relation to his characterization as the arrangements in place between the claimants and Samir as not being repo transactions. That's what I addressed.
Understood.
Yeah.
And now let's just make sure we go over your background a little bit. You are primarily an accountant, is that correct?
I'm a qualified accountant, that's correct.
So you don't have a law degree, correct?
No, I don't have a law degree.
And you have no legal background to speak of, is that right?
That's correct.
Okay, so you're not a scholar of international investment law, correct?
No, I'm not.
And you have no specific expertise in investment management services, is that correct?
Well, I have a graduate diploma of applied finance and investment from the Financial Services Institute of Australia, but I haven't practiced in that industry.
Understood. And you have, you're not a commodities trader, right?
No, I'm not.
So basically, the opinions that you've given in your report and that you that are part of the presentation that you made earlier are given in your capacity as an accountant. Is that correct?
I think that's fair. And just to add, I mean, we make it clear at the start of our report that we're not expressing an opinion on the legal case.
Understood. And your analysis and conclusions were based solely, as I understand it, on documents made available to you by counsel for Morocco. That's what you said in, I believe it's paragraph 10 of the report. Is that right?
That's correct.
Okay. And you were, as you indicated in your presentation, you were provided instructions by counsel for Morocco, correct? And you, I think, identified those instructions, right?
Yes, I identified those at the start of my presentation.
Right. And the list of documents that you are relying on for your conclusions is limited to what is contained in Appendix B of your report. Is that correct? That's, I think, on page 70 of your report.
Well, I wouldn't. They're only the documents that we exhibited. Mr. De Geer in particular, spent a significant amount of time looking at hundreds of documents, hundreds. So these are the documents we specifically cite in our report.
Right, but these are the documents that you, I believe, testify that you are relying on, correct?
Well, these are the documents in addition to, you'll recall that we cite claimant exhibits, respondent exhibits throughout the report, which aren't listed here, for example. So, CZ 0032 or Mr. Zuick, some of Mr. Zuick's exhibits, some of, from the various hearings beforehand. So, or submissions, I should say. So it's not just these documents, no.
Well, again, I understand that Mr. Dagyar has also relied on certain documents here, but I'm referring specifically to what you relied on. And I'm also specifically referring to the title of the appendix, which says documents relied upon and exhibits. And although you or Mr. Dagyar may have referenced other documents, these are the principal documents you relied upon, is it not? Are they not?
Well, me personally, but no, that's not right, because you also see above the exhibits, the RE exhibits, that we discuss the claimant's counter memorial on jurisdiction, for example. So we've looked at all of those exhibits as well. So the various filings are listed above as well. So these are just in addition to the exhibits which have already got exhibit numbers, if you like.
Fair enough. Now, turning back to page 7 of your report, you specifically noted in paragraph 11 of that report that nothing in your conclusions or opinions stated in the report is intended to address the parties' respective legal arguments. Is that right?
That's right.
Yeah. In fact, I think you alluded to that earlier in your answers. Now, in section D to your report, you offer an opinion as to whether claimant CCM controlled the investment vehicles Q1 2014 and 2015-1 under accounting guidance. Is that correct? I think you reiterated that in one of your slides, but is that correct?
So when you say section D?
Section D to the Versant report.
Are you talking about section 2?
Well, I believe no, I think I'm talking about section D, paragraphs 27 through 32.
Okay, so this is section 2, subsection D. Okay, I'm with you.
I'm sorry, I didn't give you that was a subsection, correct? My mistake. My mistake.
Okay. Sorry, so I just need to read the question.
No, it's simply a confirmation that.
Yes, based on accounting guidance. You're correct. Yes.
Oh. And so again, you're not qualified to opine on the meanings of the term control as a legal term or a legal concept, as that term may be used in an international treaty, are you?
No, and I made that clear in my direct presentation that this was from an accounting point of view, and to the extent it's applicable to this arbitration, that's helpful. If it's not, that's for the tribunal to decide.
Very good. Now, I'd like to show you RE Exhibit 28. I believe that's one of the exhibits in your report, okay, which is entitled Issues Arising in Commodity Inventory Finance. Now, this is a document you cited in your expert report, right?
Correct.
And this is a client alert issued in 2013 by an American law firm, Reed Smith, correct?
Correct.
Okay, now let's look at the highlighted portion here. And it says accounting issues in the middle of that paragraph. Accounting practices do not follow legal classification of a transaction. Do you see that?
I'm struggling to.
I'm sorry, it could be highlighted. Yeah.
Thank you. That's helpful.
There it is.
Yes, that's right.
Okay.
Right.
And you agree that control for accounting purposes is distinct from control for legal purposes, correct?
I think it could be. I mean, my experience with commoditized lending would be, and from what I understand about true sale and various other aspects of these instruments, is that with jurisdiction will treat things differently from a legal point of view in different jurisdictions, whereas the accounting rules will potentially contradict a legal view. So I guess that's right.
Okay. And so we're clear, the control that's relevant for accounting purposes is for the specific purpose of when a company is determining whether to file consolidated financial statements. Isn't that right?
Yes, that's what it's used. That's what it's used for. Yeah.
Okay. In fact, that's a conclusion that you yourself make in paragraph 114 of your report, which is on page 46. I don't know if we can turn to that. Can we turn to that, please? And where, okay. And where you write in the last sentence, the concept of control, and let's highlight that, is an important consideration for fund managers because it often determines whether a fund manager should consolidate funds it manages on its balance sheet, correct?
Yes.
Okay, in other words, for accounting purposes, the question is whether an entity controls another entity. And if it does, then the financial statements for the entities should be consolidated. Isn't that right?
Generally, that's right, yes.
So
there may be.
I'm sorry.
I was just going to say that occasionally there are exemptions, but that's true.
So even though the entities are legally separate, you would account for them as if they were a single unit, correct?
If there was control, yes.
And just so we understand, your testimony in the context of this case, if CCM controlled Q1, 2014-1, and 2015-1, under your accounting analysis, CCM would consolidate these entities' financial statements with CCM's. Am I understanding that correctly?
Yes, unless there's certain exemptions, and I think Mr. Zurich alluded to one as well. That sometimes there's pass-through arrangements, but you would get audit guidance on that. But what you said is correct.
Okay, and in other words, your report goes no further than the concept of control as provided for accounting purposes by IFRS 10 and ASC 810, correct?
It certainly applies those concepts, but what I also said in my direct presentation. I mean, the concept of control, insofar as it relates to accounting guidance, is also designed to reflect the economic reality.
Right, but for purposes of your report, what your conclusions are based on IFRS 10 and AS 810.
Yes, my instructions were to look at control from an accounting perspective, and those are the relevant standards.
Okay, and let's take a look at what you cite in your report as IFRS 10, which is RE20, which you cite in your report as well. And I'd like to direct your attention on page A542. If we could go to that, please. Okay, to the part that says parents that control one or more entities, subsidiaries, to present consolidated financial statements. Do you see that?
Yes, I see that.
Okay. Now let's look at ASC 810, which is shown in RW 72. Okay. Now, specifically looking at AS 810.10.10.1 on page 1 of this document, it says that the purpose of consolidated financial statements is to present primarily for the benefit of the owners and creditors of the parent, the results of operations and the financial position of a parent and all its subsidiaries. Do you see that?
I see that.
Okay. So just like IFRS 10, ASC likewise concerns the circumstances of when to consolidate financial statements. Is that fair?
That is fair.
Okay. And it too is invoked primarily in the context of parent and subsidiary entities and when those entities constitute a single economic entity, correct?
That's fair.
So you would agree that both IFRS 10 and ASC 810 are concerned with control of a subsidiary by a parent, correct?
Well, it doesn't necessarily have to be a subsidiary. As I said before, you can have control. Both the IFRS 10 and ASC 810 provide for instances of control where you don't have a normal subsidiary relationship like a shareholding of 100% or whatever it is. So they provide for circumstances where that might exist. It's rare, but it does exist.
But just to be clear, I mean, you have focused in what you've relied on with regard to the parent subsidiary type relationship, and the standards you cite do not offer any guidance as to, for example, ownership, correct?
Well, I've come at it from applying the guidance in the standard, whether or not it is a subsidiary or not. I looked at what the relationship was between CCM and the investee funds and applied the guidance. In particular, as I said, I focused on IFRS 10. I took into account all of the facts and circumstances around the relationship between CCM and the investee funds. That was whether it had a direct interest. That was under the portfolio management agreements. That was around the remuneration arrangements. That was everything. So I followed the guidance as it applied in IFRS 10.
Fair enough. But we can agree that in terms of the actual factual relationships, none of the entities that we've mentioned, 2014-1, 2051, or VMFQ1, are subsidiaries of CCM, and that's not been alleged. Is that correct?
We agree that there's no direct interest from CCM to those entities, absolutely.
Okay, well, they're not subsidiaries. That was my question.
Yeah, we might be talking about the same thing, but there's no shareholding and there's no at-risk capital from CCM.
Well, that's a different issue. What I want to make clear that to your knowledge, claimants have never alleged that CCM is a parent of the investment vehicle.
Yes, I've not seen that.
Okay.
No.
Now, in your review of claimant's case, and you've indicated that you've reviewed that, isn't it true that, well, setting aside that, isn't it true that a significant amount of judgment is involved in making the determination of control under accounting guidelines themselves?
There can be, for sure. There can be a significant amount of judgment required. I think in this case, it's pretty clear cut because of the issue we just discussed, that there's no direct investment. So the illustrative guidance in IFRS 10 is conclusive in this case, but there are certainly examples where it is difficult and subjective.
Well, actually, let's look at an observation that you made in your report. If we can turn to that report, paragraph 129, page 15. Okay, and there you say, whether or not control exists for an investment manager under IFRS turns on the question of whether the investment manager is a principal or agent. The previously described three elements of control are the factors to be weighed in reaching a conclusion. And then you say, this will often involve a significant amount of judgment. So you don't deny that, correct?
No, I think that's consistent with what I just said.
Okay, and so reasonable minds may differ even under these accounting guidelines as to whether a relationship of control exists.
Generally speaking, that is possible, but I think in this case, as I've said, the guidance is conclusive with respect to CCM because of the lack of direct interest.
Right, but you don't deny that this is, again, as part of your report, it is a fact that a significant amount of judgment is involved. There's no objective factor, in other words.
Well, with respect to, it depends if you're talking about CCM specifically or if you're talking generally, because...
Well, I'm talking generally about what you've said, because you've indicated, you've referred to these guidelines. All I'm trying to point out is that under these guidelines that you've relied on, okay, you've acknowledged that a significant amount of judgment is involved in making the determination that you have made. Obviously, you have made it, but there's a significant amount of judgment involved, and you don't deny that.
I stand by what I said in my report, which says there's often a significant amount of judgment required, but I don't believe there's any debate in this particular case.
Okay. Now, let's turn to the Ernst & Young report, which you also attached as an exhibit, which is RE 21, and it's a report on IFRS 10. This is also a document that provides guidance on the application of that principle or rule, IFRS 10, right?
Yes.
Yeah, and it was prepared by Ernst & Young, one of the big four global accounting firms, correct?
Correct.
So you have no reason to question the guidance from Ernst & Young, correct?
No.
And as we established, you relied upon this document in your report, and that's because IFRS is one of the accounting guidelines you examined in your report, right?
That's correct.
And so let's turn to page 5. And what I'd like to turn to is that part of it where you say different conclusions of consolidation conclusions will not only be driven by new guidance under IFRS 10, but also by the level of judgment its application requires. You see that?
Yes.
Okay, so the consolidation conclusions referenced there refer to control under accounting guidelines, correct?
Yes.
Okay, so you agree with Ernst & Young's conclusion that those conclusions also are judgment calls, if you will, that can lead to differing conclusions. We understand what your conclusion is, but you agree that differing minds could, a different conclusion could be reached. Is that right?
I think in certain circumstances, that's correct.
Okay. And a change in accounting guidance may lead to a change in how you evaluate and report matters, even though there's been no change in the legal structure. Isn't that true?
It's possible, yes.
Okay, now you have acknowledged, Mr. Taylor, that CCM provided investment management and advisory services to the Master Fund, Q1, 2014-1, and 2015-1, correct?
Correct.
Okay, and this was done pursuant to multiple investment management agreements or portfolio management agreements between CCM and each of those entities, correct?
Correct.
Okay. Now, you didn't list you didn't list those documents, as I understand it, in the documents you relied on. But let's turn to them.
Could I just interrupt you there? Sorry to,
sure.
but I did list them in my report. They're all footnoted, and as I said to you at the start, sorry, when we were discussing the documents, the claimants' filings and the respondents' filings are listed as documents we relied upon. All of the documents are footnoted whenever I've cited them.
Fair enough. In other words, they weren't specifically listed, but you meant to include them as attachments. Is that what you're saying?
Well, we referred to the claimant submissions, which would include all of the associated exhibits. In my report, I footnote the precise exhibit numbers.
Well, let's look at one, CZ 37, which is the offering memorandum for the U.S. onshore feeder. Okay, it's the offering memorandum for Celadon Commodities Fund LP, which I represent to you as the U.S. onshore feeder. I'm sure you won't disagree with that. So you reviewed this document in connection with your work?
I'm just looking at the group structure here. So which entity is this, sorry?
Well, the Celadon Commodities Fund LP has been referred to in this case, and it's identified as the U.S. onshore feeder. So the question here is, did you review this document?
No, I think I reviewed the portfolio management agreements for 2014-1, 2015-1, and the investment management agreement for Q1, if I'm not mistaken.
Okay, so this is not a document that you reviewed?
No, because I was asked to determine whether CCM was controlling those three entities I just mentioned.
Okay, so that was part of your instructions. But let's go to the PDF here, page 7, which contains a directory. And then you see there that Celadon Commodities Partners LLC, one of the claimants here, is listed as the general partner. Do you see that?
Yes, I see that.
Okay. And you see that Vermilion Asset Management, which is known as CCM now, is listed as the investment manager. Do you see that?
I see that.
Okay, and the same address is listed for both Celadon Partners and CCM, right? It's 267 Fifth Avenue, New York, New York.
Yes, I see that.
Okay. Now let's turn to page 16 of this document, which is in the PDF, page 25. And under the section heading Management Authority, it says, under the partnership agreement, the general partner is vested with the full and exclusive authority to manage and control the partnership's business. Do you see that?
Yes, I see that.
So according to the offering memorandum, the general partner, who we just established as Celadon Partners, is vested with full and exclusive authority to manage and control the U.S. onshore feeder, right?
Right.
Okay, and in turn, the last sentence of that paragraph states that the general partner has delegated the authority to manage the partnership's portfolio to the investment manager pursuant to the investment management agreement. You see that?
I see that.
And we've also established that the investment manager to whom this authority was delegated is CCM, correct?
That's what it said earlier, yes.
And so then based on this, isn't it a fact that CCM had full and exclusive authority to manage and control the investment decisions of the U.S. onshore feeder?
It had the rights that were outlined in the investment management agreement.
Okay, and those include the full authority to manage and control those investment decisions of the U.S. onshore feeder.
As I said, I haven't read the agreement, but if it'll be outlined in the agreement, just as it's outlined in the portfolio management agreements for, the notes entities, for example. So I'm not disputing it.
Okay, so you don't deny that it says what I've just iterated, correct?
So perhaps Mr. Ordway can clarify what he has just iterated.
Well, all I meant to say is that based on this, isn't it a fact that CCM had full and exclusive authority to manage and control the investment decisions of the U.S. onshore feeder? Was identified who the U.S. onshore feeder here is?
Yes.
Identified who CCM is. It says
yes.
Okay.
Yes. So I think under the investment management agreement, they have that authority. Yes.
Okay.
And can I just put then a question, because it comes immediately. So sure. If Celadon Partners LLC, as the general partner of the onshore feeder, do you know whether there was consolidation?
So who are you asking that to, Mr. President?
Mr. Taylor.
Right.
You are the expert. Yeah, apparently you said you are an expert in accounting. So,
well yes, but
because we have discussed one of the questions is we have all discussed, and the council has led you to this question that control is relevant for consolidation, but you can also do it the other way around. If there is consolidation, there is control. If there isn't consolidation, there isn't control. So I don't know if you have done the test the other way around.
No, I haven't, Mr. President. All I looked at was CCM's relationship with Q1, 2014 one, and 2015 one, and looked at the arrangements in place between those entities.
And did you look at the financial statements of CCM to see if they consolidated these three companies?
They were not provided to me, the financial statements. And I think Mr. Zuick actually, I think he confirmed in his evidence that they were not consolidated. I could be wrong on that.
I think he said, to be very fair on him, that I asked a similar question to him, and I think he said that he did not remember the consolidation arrangements of the Carlyle group.
Okay.
I think that is what he said. Okay, sorry to make that interruption.
No, that's quite all right.
Because it should. We are always looking at it from the point of view of whether there is control. But if there is control, the expert has told us there should be consolidation. So we could also look at the consolidation, whether there actually is consolidation.
Thank you, Mr. President. So let's take a look at the management agreement of the U.S. onshore feeder CZ35. Okay, this is the investment management agreement by and between Celadon Commodities Fund, LP, Celadon Commodities LT, and VAM, which is now CCM. Correct? Was this was not one of the documents you relied upon?
No, as I said, I looked at the arrangements in place with the three investee funds and CCM.
I'm just confirming, that's all. So one of the three parties to this agreement was Celadon Commodities LT, also known as the Master Fund, correct?
Correct.
Okay. And then you understand that the U.S. onshore feeder, or in this agreement, Celadon Commodities Fund is one of the claimants in this case, correct?
So which entity is it?
Celadon Commodities Fund LP.
Right.
Okay. And you understand that the claimant's position is that the U.S. onshore feeder contributed funds to the investment with Samir, correct?
I don't know.
Okay. Well, let's turn to section 5A, which is on page 3 of the document and page 4 of the PDF, where it says, subject to the investment guidelines, the fund hereby grants investment manager complete discretion in the investment and reinvestment of the account. Do you see that?
I see that.
Okay, and that means that CCM, as the investment manager, had complete discretion over the funds in the account of the U.S. onshore feeder, correct?
That appears to be correct, yes.
Okay. Now I'd like to turn to CZ 47. And here, I believe, is a document that you did review, or at least based on what you've said. And this is the investment agreement between CCM and VMFQ1, correct?
Correct.
Okay. And of course, you're aware that VMFQ1 was a counterparty to Samir in the transactions at issue in this case, right?
Yes, that's correct.
Okay. And yet again, this was, so turning your attention to section 1 on page 1 of the document and page 2 of the PDF, which is entitled Duties of the Investment Manager, do you see that it says the investment manager is hereby appointed as the company's limited attorney in fact to invest and reinvest the net assets of the segregated portfolio in such a manner as the investment manager may determine in its sole discretion. Do you see that?
Yes, I see that.
Okay. And turning briefly to the first preamble paragraph on that same page, CCM is defined as the investment manager here, correct?
Correct.
So, in sole discretion means only CCM and no other entity had discretion to make those investment decisions, correct?
Correct.
Okay. So, under the plain terms of this agreement, the directors of Q1 ceded to CCM sole investment discretion over the assets of VMFQ1, right?
That's appeared to be what it says, yes.
Okay. And turning to section 2, which starts on that same page, this section outlines the authority of CCM as investment manager, correct?
Correct.
For example, section 2B authorizes CCM as the investment manager to, and I quote, possess, purchase, sell, transfer, mortgage, pledge, or otherwise deal in and to exercise all rights, powers, privileges, and other incidents of ownership or possession with respect to its assets, right?
That's what it says.
Okay, and
Mr. Ordway, sorry to interrupt you.
Sure.
I made the same point to Mr. Harris, that Mr. Taylor is not a lawyer. He's not a legal expert. We have gone through these documents, and wouldn't this be to make any point about what these investment management agreements actually say? Wouldn't it be better that we leave it for tomorrow? Can Mr. Taylor really help us in interpreting these documents?
Fair enough. If what you mean by that is that perhaps we could omit.
Shorten this, if you can shorten this, because I mean we have gone already. I mean I had gone on myself, and we have gone already once or twice today through these documents, and we know them rather well. So I see your point, and you insist, of course, by its sole discretion and so on. But I think the tribunal is perfectly aware what these documents say, and I'm sure that we can use Mr. Taylor's presence here to get some more technical expertise on accounting, which is his field of expertise.
Fair enough. Then I will shorten this significantly then, Mr. President. But what then I would like to do is go over a point that was specifically addressed as one of the indicia, if you will, of control, which is power over the investee. And so for that purpose, I've like, it's true that IFRS, one of the elements of an investor's control over an investee is, as you've said, power over the investee. Is that correct?
That's certainly one of the things you need to consider, yes.
Okay. And isn't it also true that under IFRS 10 that an investor has power over an investor when the investor has rights that give it the ability to direct relevant activities that affect the investee's returns? Isn't that true?
That is true. That's one consideration.
Okay, in fact, let's just put it up on the screen here because it's in IFRS 10 at clauses 10 and 12. If we could highlight both 10, And okay, and then it also says that the power results from one or more contractual arrangements. This is in 11. This is up in yes, and then it says that evidence in 12 that the investor has been directing relevant activities can help determine whether the investor has power. But such evidence is not in itself conclusive in determining whether the investor has power over an investee. But it is evidence, is it not?
Yeah, that's what I said. It's a consideration for sure.
Okay. I'm trying to shorten this, Mr. President, so that we don't have to go any longer than is necessary. All right, now let's turn to the comments that you make with respect to Mr. Walk's second report. Now, in this respect, based on the presentation that you gave, you offered some commentary on statements made by expert Rory Walk, claimant's expert, correct?
That's correct.
Okay, and that's contained in section 6 of your report, and in this portion, you take issue basically, as we've seen in your presentation, primarily with one of Mr. Walk's observations, and that is the question of whether the Carlisle Samir transactions should be considered repurchase agreements, right?
That's correct.
Okay, and then in your report, you say that commodity repurchase transactions, such as the arrangements involving the claimants and Samir, are commonplace, right? But nowhere do you cite to the actual agreements between claimants and Samir themselves, do you?
Well, as I said before, that Mr. De Geer had covered the arrangements in place between the claimants and Samir, and that's to that extent I relied upon his analysis. Okay,
but those are not. In other words, that you yourself did not rely on them. Mr. Daguiar relied on them. That's what you're saying. You relied on his conclusions.
Yes, that's fair. I relied upon Mr. De Geer's interpretation of the arrangements.
Okay, but and I believe you referred in your presentation and in your report also to the Kimura white paper. Is that right?
That's correct.
Okay. Now, is that because you yourself reviewed the white paper, or was this what Mr. Daguiar reviewed?
No, I reviewed that white paper.
Okay. But the Kimura white paper doesn't reference claimants' agreements with Samir, does it?
No, it doesn't reference that specific agreement. No, it talks in more general terms.
Of course. And in paragraph 159, you write that the repurchase transactions involve a customer, in this case, Samir, selling a commodity to a lender. Correct?
Yes, that's correct.
Okay. And are you aware that the master commodity transaction agreement, and then for the sake of brevity, we won't go into it, but that agreement never refers to Carlisle as a lender a single time?
I don't know if that's true or not.
And you don't know if that's true because you haven't reviewed that agreement?
I've certainly looked at the MCTA. I can't say that it never refers to Carlisle as a lender. The comments at my paragraph 159 are taken in the general sense. So,
okay, well, let's actually then look at the MCTA, which is CZ 2. MCTA at paragraph 16. And we've looked at this, but again, I'm presenting it to you. And do you see where it says in 16A, each transaction be a sale of the commodities by the counterparty to VM party and not a transfer of the commodities to VM party as security for a loan. You see that?
I see that.
Okay, so in the actual agreement, the parties acknowledged that the transactions involved a sale of the commodities and were not a transfer as security for a loan, as is typical in a repurchase transaction, correct?
Well, no, that's not correct, because the a typical commodity repurchase agreement anticipates a true sale arrangement with the transfer of title.
Okay, well, we're in agreement that here it's very clear that this is not security for a loan, correct? That's what the agreement says. Am I correct?
That's what that agreement says.
Okay. And in the commonplace commodities repo transactions that you've been referred to, you refer to in your report, they do typically involve a loan. Typically, isn't that correct?
Well, it's a financing structure, but the commodity repo arrangement involves transfer of title to the lender.
Right, but that was not my question. It doesn't typically involve a loan, isn't that right?
So if we go to my statement at paragraph 159, where I say, quote, they involve a customer, in this case Samir, selling a commodity to a lender, in this case Carlyle, and simultaneously agreeing to buy it back at a fixed or determinable future date for a pre-arranged price or against a determinable formula.
Right, but the reference there, Mr. Taylor, with all due respect, is to a lender, and a lender is a person who makes a loan, correct?
Well, you're characterizing it as that. I'm not suggesting it's a loan. I'm just telling you that's how Kimura and others. There's another exhibit I provide, Sullivan and Worcester, also talk about the structure itself.
All right, well, going back to some of the elements that we've been talking about that characterize these transactions, one of them was that it had a storage agreement, correct?
Yes, the arrangements between the claimants and Samir has a storage agreement, yes.
Right. And under that storage agreement, Samir couldn't use or remove the commodities unless Carlyle provided written consent, correct?
I don't know, but I'll take your word for it.
Okay. Well, we can show that to you, but in the interest of brevity, we'll move on. Would you agree that those are not really common features of repurchase transactions, storage agreements?
I would not agree at all, because the graphic I provided you in my direct presentation from Kimura anticipated exactly that, having a storage agreement, and I think it even referenced a storage agreement with the seller.
But it's fair enough that those the types of transactions that you're referencing do not involve intended arrangements over a period of years. Isn't that a fair statement?
It doesn't talk about the tenor. It talks about the fact that there's different periods of time agreed certainly in the Kimura transaction, and it specifically referenced storage arrangements along with insurance and other things, right?
But isn't it a fact that typically any kind of repurchase agreement does not involve multi-year arrangements? Isn't that a fair statement?
Well, in this case, we're talking about 16 transactions and the confirmations rather than, you're talking about the MCTA having an overall three-year period. Is that what you're talking about?
Well, I'm talking the fact that the intended investment was for a 3-year period. And all I'm trying to say is that isn't it a fact that repurchase transactions of the kind you've been describing do not normally involve multi-year arrangements? Isn't that a fair statement?
I think what it relates to is the 16 specific transactions. They are the repo transactions.
Okay, so you're basically basing your conclusions on not the investment as a whole, but simply those specific transactions that you were asked to look at.
Yes, I'm looking at the transactions. That's right.
Okay. I don't have any further questions, Mr. President. Thank you, Mr. Taylor.
Thank you, Mr. Albright.
Thank you. Thank you, Mr. Ordway. And so we now give the floor to respondent.
Thank you very much. I only have a few very brief questions.
Mr. Talfoun, thank you.
The first question, Mr. Taylor, you were shown a series of contractual documents and you were shown various clauses in these contractual documents that referred to various discretions granted to CCM. And you were asked whether that meant that CCM controlled the relevant entity. And in relation to the US onshore feeder in particular, you were asked, does that mean that CCM controlled the onshore feeder? And you answered yes, that it did. I just wanted you to clarify whether you meant this in the accounting sense or in any other sense.
No, certainly I don't believe that it controlled from an accounting point of view. I think I was talking about the decision-making authority as it was explained to me by Mr. Ordway.
The second question simply follows up on a question from Ms. President of the Tribunal, which is whether the Carlyle Group itself consolidated certain of these entities within its account. So in a sense, its own accounting judgment. And perhaps you might assist as to where one might be able to find evidence as to whether or not the Carlyle Group consolidated the various entities. And I'm thinking in particular 2014 one, 2015 one, and Q1. Where would one look to see whether they were or not consolidated?
So there would be in their SEC filings, I assume, that they would have to list all of the subsidiaries that they treat as subsidiaries and are consolidating. Certainly, you wouldn't be able to see in Carlisle's financials because of materiality issues, but I believe they should be listing the entities as subsidiaries within their filed accounts.
So just to understand, if we wanted to find out whether in 2015 they were consolidating these entities, we'd have to look at the SEC filings, at the list of subsidiaries, and try to see whether the relevant entities were listed. Is that what you're saying?
Well, that is one way. Yes, I mean, yeah, it'll also be interesting to see the intermediary entities as well might be informative as to the extent that they have available financial statements as well. I think, as Mr. President alluded to, so you could certainly get some visibility as to who, certainly in Carlyle's interpretation, was controlled.
And are the SEC filings in the public domain?
Yes.
Mr. President, I have no further questions.
Thank you. Thank you very much, Mr. Chalfoun. Let me now look to my colleagues. Let's now start with Mr. Wordsworth. QC, do you have any question for the expert?
I do not, thank you.
And Professor Grigeranaon?
Nothing on my side either.
I do have one or two questions. Mr. Taylor, you are an accountant and your specialty is accounting.
Accounting and valuations, damages assessments.
But if I ask you some questions about accounting, I am within your area of comfort.
Yes.
Very good. So, because I don't think you have actually touched on this in your report. So if you feel uneasy about what I ask, just tell me I don't know, and I would need some additional time. So I don't want to catch you unaware. But I want to try to understand what you call a repo transaction and what we will just call, in order not to establish the transactions between Q1 and Samir. I wanted to understand how you as an accountant would account for these. And I wanted to start, have you ever given some thought how Samir would account for these transactions, for these 16 transactions?
I have given it some thought, and I think one of the benefits to Samir as a result of this arrangement was that because of the true sale nature of it, it was likely to be off-balance sheet arrangement, so there wouldn't be a liability recorded necessarily on the balance sheet, because Q1 would take title to the commodity. So I think from Samir's point of view, it would be relatively attractive.
Okay, so in Samir, there would be some note somewhere saying that they have a put option against themselves and the call option against the Q1 for certain amounts. Would show up in their notes, just in the notes to their account?
Mr. President, now you're asking me to opine on Moroccan
No. No. Under IFRS. No.
IFRS.
I mean, Samir is a very big company, and I'm sure that, let's assume that we do everything under IFRS, which you are. Of course, we are all not familiar with Moroccan gaps, but
yes, you would expect to see some disclosure to that effect. Yes.
Very good. Now let's move to the other side of the equation. How would you expect Q1 to account for the transaction? If you feel uncomfortable, just tell me, because I know you have. It is not, or I have not seen it in your.
No, I haven't.
I don't want to catch you unaware about that.
Yes, no, I won't go too much further, but I think, and it's not something that I considered specifically, but I think it's common ground amongst all parties that it was dealt with as a true sale. So they would be recording the commodity as an asset. But then you have the added complication of the sleeve transactions with the notes entities.
You have preempted my next question. So my first question to you is the purchase would be a true purchase, and they would then have it as a commodity assets between as a commodity, and they would have some disclosure in a note or somewhere that there is a put and a call. Would that be your expectation?
Yes, but I was trying to, when Mr. Yohai made a comment in the openings that I was trying to understand, and it was around whether the title to the commodities moved from Q1 to 2014 one and 2015 one, but I think he said that the title remained with Q1, but there was contractual obligations to the notes entities, and I was trying to work out in my own mind how the accounting worked for that.
No,
So,
I don't think I said that exactly. What I said was in some instances it moved to 2014, in other instances Q1 retained title. That's what I said.
Okay.
Mr. Taylor, I will make you now the question, because the next question is, of course, how is the sleeve transaction registered in the accounts? If I will make you the telephone question. If the tribunal wanted to know about how this has been recorded in the Q1 accounts, knowing that Q1 does not have a balance sheet because it is a look through to Celadon Commodities. If I were to look at the Celadon Commodities accounts, I would see it there.
Well, you would, to the extent that there was an obligation to the notes entities, and you would expect to see that in the entity that was taking on the Q1 look-through arrangements. So I would think, candidly, I don't know how or even what that accounting treatment would look like.
Very good. Very good. Thank you. Thank you for trying to give an answer to something which you had not actually studied. I don't know if there is any follow-up question, because this was a rather unexpected question from me. Mr. Yochai or Mr. Chalfon or Mr. Otway, do you have any follow-up question?
I may have a very brief question. And Mr. President, simply it is a follow-up to the question you have just asked as follows. In your question, you mentioned that Q1 does not have a balance sheet, but it is a look-through entity to Celadon Commodities. And I just wanted to ask perhaps whether Mr. Taylor could explain whether as far as he understands it from an accounting point of view, Q1 is an entity of its own or otherwise, or whether it is simply a look-through entity on that point. If that would be helpful at all to the tribunal.
I said that because it was said, and I think it was said today by Mr. Suek. So that is where I got this information. I asked yesterday, and maybe Mr. Yochai also gave a similar answer yesterday, that they had and this is the reason why they had no separate accounting. But yes, let us get this information from our expert on accounting, whether whether he has any comment to that information which was provided to us.
Well, I also heard Mr. Zuick say that it became a look-through entity, I think by virtue of the 100% participating shares from the master fund. But I'm sorry, I can't recall sitting here whether I've seen any financial statements for Q1. It may be the case. I don't know. I'm sorry.
Very good. Any further questions for our expert?
Not from claimants, I believe.
Thank you. Thank you. Mr. Taylor, thank you very much for your efforts today of being here with us in trying to better understand these complex accounting issues. With that, we finalize with you. You are welcome to stay with us. And we had said that we would we are well within time. Shall we now break for half an hour? So before we call Mr. Walk, would a half an hour break be appropriate, Mr. Harris?
Entirely in your hands, sir. Whatever you prefer.
We said 25 minutes. If you prefer 25 minutes.
I'm relaxed.
Well, actually, I think we would prefer 30 minutes because we would like to have a little lunch. So if we could have that.
Very good. You have a light lunch and I have a light supper. Very good. So we come then back at 19:35 Madrid time, whatever is the appropriate times in different time zones.
Thank you, Mr. President.
Ernesto, it looks like everyone's back.
Very good. So we resume the hearing and we do so to depose Mr. Walk. Mr. Walk, welcome back.
Thank you, Mr. President.
Mr. Walk, you are here as an expert. And the first thing we have to do is we have to take your oath as an expert. And the secretary will now put on the screen the formula which you have to take. We have to wait a little second. So this is the expert declaration. Mr. Walk, can I kindly ask you to raise your right hand and to take your oath?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Thank you very much. And with that, I give the floor to counsel to claimant.
Thank you, Mr. President. Would you state your full name, please?
Richard E. Walk.
Mr. Walk, you have submitted, I believe, 3 expert reports in this arbitration. Do you have any corrections to make with regard to any of those reports?
No, I don't.
Thank you. I have no further questions. I think Mr. Walk has a presentation.
Excellent. Mr. Walk, we have to give the appropriate number to your presentation, and it should be H6.
Very well.
And you have the floor.
Thank you, Mr. President. Good afternoon, Mr. President and members of the tribunal. I'm Rory Walk from Global Financial Analytics, and I've been asked to address 3 issues in connection with the jurisdiction portion of our hearing today. First, the nature of the Carlyle Samir investment transactions. Secondly, the relevance of accounting standards for consolidation in financial statements to the question of control under the Free Trade Agreement. And third, the commodities that were in inventory at Samir at August 7th of 2015. Respondent has asserted that there's a simple repurchase financing arrangement here. In their reply, they said that all the evidence confirms that these were financing arrangements akin to a repo financing, and they've used a number of demonstrative items, including this one that I've put up from Samir, from a board of directors presentation prior to the close of the transactions to support that proposition. But the actual structure of the transactions was considerably different. It combined ownership of the commodities with derivatives hedging. So if we start with a correct...
Mr. Chair, I appreciate someone else might need to intervene, but I believe this is protected information. This is a matter for Carlisle, but I believe this is protected information.
Yes. Yes. It is.
So the Carlyle Samir transactions do not require Carlyle to sell the commodities back to Samir as a repurchase agreement would. And on this point, I noted in Mr. Taylor's testimony, he referred to the Kimura report to a diagram that said that a commodities repurchase agreement can be on fixed terms, or it can incorporate call and put options. And indeed, in his slide, I believe it was number 15, he asserted that Samir held a call option on the commodities. I don't believe that's true. And I think that's a distinguishing factor in Carlisle's investment that results in Carlyle having no obligation to resell to Samir. Similarly, the structure was not one of secured lending, nor was it accounted for that way. Turning to the question of control, we heard Mr. Taylor talk at some length earlier today about control under the accounting standards. And we heard from Mr. Harris 2 days ago in his opening statement. I believe he put this same provision from the free trade agreement up. The free trade agreement, of course, is what we'll be concerned with here. So the question then is, what relevance do the accounting standards have? And I would suggest they have pretty much no real control over what's going on here. Accounting standards are designed for a specific purpose. They're designed to ensure comparability of reporting across firms for financial statement reporting purposes. And that's important to investors and other users of those financial statements, but they're not intended to determine legal issues. And there are, in fact, a number of instances in which accounting explicitly disregards legal status. I've put a few examples up here for you. IFRS 15 deals with the recognition of revenue from contracts. And it says that even if the sale hasn't been completed, there are circumstances in which an entity will recognize revenue and profit despite the fact that no title has passed, no sale has yet occurred. In IFRS 16, which is a fairly recent one that governs changing the way accounting for leases occurs, it now requires, if you are leasing your assets, that you recognize an asset, a new category of asset called a right of use asset, that you recognize a liability as if you had a mortgage on that asset. And so you account for leased assets just as if you owned them, even though you have no legal title. The objective there was to make comparability between firms that lease their assets and firms that own their assets easier for the users of those financial statements. And in the process of doing so, the International Accounting Standards Board recognized that this was going to completely turn on its head certain financial metrics that had long been used. I'm sure the tribunal has heard the term EBITDA, earnings before interest, taxes, depreciation, and amortization, that has been used for decades as a proxy for the cash flow that a company generates. And indeed, many purchase transactions have been done as a multiple of EBITDA. But now if you're leasing your assets, EBITDA becomes a completely meaningless concept because you're adding back your lease expenses, even though cash is going out the door to pay them. And with respect to IFRS 10, which Mr. Taylor has talked about, it's directed toward accounting for consolidated reporting. So you treat multiple entities as a single entity, even though they have their own legal persona. And I would note that IFRS 10 has a number of exclusions and ins and outs that you have to wade through when you're dealing with investment entities. So we have to keep in mind that accounting standards have their limitations. They're useful for accounting and reporting purposes, but they ignore the legal realities. They treat leased assets and owned assets as if they were all owned. They treat completed and uncompleted sales as if they had all been completed. They treat separate legal entities as if they weren't separate anymore. And they're not always required. You heard Mr. Taylor speak earlier about materiality when talking about what you might be able to find in Carlyle's financial statements. Carlyle, of course, is a very, very large company. It manages something north of $200 billion. So to find entries relating to the entities that are at issue here is quite unlikely because they're simply not material. In a similar vein, I had an audit client a number of years ago, a subsidiary of what is now Verizon. At the time, it was GTE Corporation. And the subsidiary I was auditing had, in turn, a wholly owned subsidiary that it didn't consolidate. It accounted for it on the cost basis. A clear violation of GAAP, but one that was not material, and so it was fine. And there's the catch-all exception that the accounting regulators put in that says if other reporting would be more informative for the user of financial statements, and you can justify that alternative reporting, you're free to do so. So the bottom line on accounting standards is they don't substitute for international law, nor do they substitute for the specific contract or treaty language. Turning finally to the question of whether the commodities that Carlyle purchased existed as of the August 7th intervention of the government, the respondent has suggested that a significant portion, and maybe even all of the commodities, had long since ceased to exist. So I took a look at the inventory tank reports that Samir submitted, dated immediately before and after that intervention. The August 2 inventory showed 476,000 metric tons of the same type of commodities that Carlyle had purchased. That's something on the order of 600,000 cubic meters, or a little bit under 4 million barrels of hydrocarbons, plus additional volumes of other eligible products that Carlyle might swap for. If we drill down into that, we see crude oil, fuel oil, gas oil or diesel, gasoline, jet fuel, and naphtha. Those are the specific products that Carlyle purchased or swapped for that are at issue in this arbitration, in addition to the other quantities of other eligible commodities, propane, butane, and so forth. If we look at August 9, we still see 400,000 metric tons of those same products. And drilling down again, we have the crude, fuel oil, gas oil, gasoline, jet fuel, naphtha, and the other eligible commodities. So in summary, the transaction structure, as I see things, was a complex multi-year arrangement that included ownership title and the use of derivatives, puts and futures to manage price volatility and other risks of ownership. The accounting standards are great for accountants. They're designed to ensure comparability and transparency in financial reporting. They're not designed to determine legal standing under a free trade agreement. And finally, the commodities inventory shows that both immediately before and immediately after the August 7th government actions, and indeed for many months thereafter, because Carlyle continued to get inspectorate and other inspection agencies certification on tank reports through to the end of 2015, and they continued to show substantial quantities of the very same products that Carlyle had purchased. And with that, I will pause and let you do cross-examination.
Thank you. Thank you very much, Mr. Walk. Mr. Ordway, is there any other follow-up question?
No, I have no other follow-up questions.
Very good. So we will now give the floor to respondent for the cross-examination. I think it will be Mr. Harris.
It will. Mr. President, can I begin before going to the cross-examination by registering an objection? I didn't want to interrupt Mr. Walt while he was making his presentation. I hope will not have escaped the tribunal's attention that in slides 8 and 9 of his presentation, Mr. Walk for the first time refers to IFRS 15 and 16. They are not referred to in any of his reports. None of the points he made in relation to them have been advanced in any of his reports. There was no opportunity, therefore, despite Mr. Walk having the last word in terms of putting in the last expert report, there's been no opportunity for Mr. Taylor to comment on those propositions, no opportunity for us to investigate them. They were not put to Mr. Taylor in cross-examination. And so in my submission, it is not acceptable for those to be put into the record, and that part of his testimony, that part of his presentation must be struck.
Yes, Mr. Ordway.
Well, excuse me, but it was my understanding that the principles being referenced were IFRS principles generally. So while it is true that those particular principles were not specifically referenced, we don't see why there should be a problem in actually referencing other accounting principles as exemplars of the points that Mr. Walk was making. Again, we defer to the tribunal, and if the tribunal believes that out of fairness to respondent that should be struck, then we obviously defer to the tribunal. But in the interest of completeness, since the IFRS principles are at issue here, and since Mr. Walk could have referred to them without necessarily referring to or showing a visual in that regard, we believe that that should be included. If it's a question of the demonstrative being struck, I don't think we have a problem with that, but his testimony in that regard, I think as a response to what Mr. Taylor said, should be included.
Thank you. If what I remember from your reports, Mr. Walk, is that you had, and please confirm this to me, that you. Let me try to explain first what you have said to us today, and then put it into perspective with what you have written. What you have said today to us is the following: that accounting principles do not always reflect legal nature of contracts. In general, that there may be contradictions between the legal aspects and the accounting aspects of the same transaction. That was the thrust of your thought. And correct. Then you gave us as examples, I think this is what Mr. Harris is objecting. You gave us as example, first, that in contracts, in construction and contracts for the providing, that you can take the earnings before you can take the profits or the earnings, the income, when they are not really due, legally speaking. Was that your first example?
Yes.
The second is that this new change in that in the leases now are assets.
Yes.
And the third one is, then you said the IFRS 10 also does not reflect, does not necessarily have to reflect the legal aspect of control. That was the thrust of your argument.
Yes, that the legal realities are not captured in the accounting standards.
Very good. And if I'm not wrong, because you referred to IFRS 10 in your report, but not to the IFRS on contracts and on leases. And you even said, and I was not even aware of, that leases now under this new 16, I think it is, that leases must be shown as a special type of assets.
Correct.
You had not referred to that in your reports. That's like a new thought which came up now.
I don't recall putting it in my report, but I don't have a report in front of me.
No, and me neither. I mean, I have read them, but it would have struck me, especially the lease would have struck me, and it didn't. It came now as a surprise. And I think, Mr. Walk, to be fair to everyone, these are new thoughts. And I think it would be proper, so that everyone has a level playing field, that we leave your, I mean, we don't strike anything out, because that is impossible. You cannot unring the bell, but that let us leave the argument, which is, I think, which you can base on IFRS 10, that accounting does not always follow legal principles, or that there may be distortions between legal reality and accounting reality. And let's exclude these examples which you gave, which are new, and we had really no possibility of double checking them with the other expert, and which are, I think, also just a side argument to what we're trying to achieve. Can we all agree that that is a reasonable solution?
Well, Mr. President, we can agree with that, but just as an amendment to that, I think it would be quite easy for us to strike that part of the demonstrative that reflects those two principles that were not previously referenced and still keep it. I mean, the idea is, as you've pointed out, is still one that's a valid one that can be raised, and it's simply the content of these other IFRS rules that is objected to. And we totally understand and accept the tribunal's ruling on excluding them. But I think that if it's not objectionable to respondent, we could alter that demonstrative accordingly.
Okay, let's do that. And let's, in the final version of H6, then we just strike out these two references and we exclude them. And so, Mr. Harris, you don't have to go into them, and we go on from there. Thank you. Thank you, Mr. Ordwait, for your flexibility. And Mr. Harris, you have the floor.
President Ordwait, can I just check one point? It's one thing to delete them from the slide, but I've understood the tribunal's ruling, and I just want to be clear about it. I've understood the tribunal's ruling that the tribunal is not going to rely on or consider those 2 points on IFRS 15 and 16 in deciding the jurisdiction phase. That's important, I think.
No, but we will take into account that Mr. Walk said that there may be contradictions between the legal reality and the accounting reality. Is that a fair summary of your position, Mr. Walk? I don't want to put words in your mouth, but now it came out better, that yes, there are contradictions between the legal reality and the accounting reality. Is that the thrust of your argument?
That is a fair summarization of the thrust, Mr. President.
Okay,
so we leave it at that, and we will not look into these two arguments.
I'm very grateful, sir. Mr. Walk, you're a qualified accountant, aren't you?
Yes.
And you've been a professional testifying expert for over 40 years, I think, haven't you?
I have testified since the early 1980s. Yes.
On damages and valuation issues, yes?
Most of the time it has been damages and valuation. There have been some other instances.
I think I understood from one of your CVs that you've given evidence around 70 times before. Is that right?
That would be about
right. You're not a qualified lawyer, are you, Mr. Walk?
No, I'm not.
And you're not a commodities trader, are you?
No.
You are a US certified public accountant, yes?
Yes.
And a chartered financial analyst, is that right?
I am not a chartered financial analyst.
As a US certified public accountant, are you bound by principles such as, before reaching a conclusion, you have to obtain sufficient relevant data to afford a reasonable basis to reach that conclusion?
Yes.
And you need to have a reasonable and adequate basis supported by appropriate research and investigation for your conclusions, yes?
Typically, yes.
And are you confident that in your 3 expert reports in these proceedings, you haven't anywhere strayed beyond your own area of expertise?
I have certainly tried not to.
And you're confident, are you, that you haven't reached any conclusions without adequate research and investigation?
I believe I have obtained adequate support for my conclusions.
Now, you've given, as we heard, 3 reports in this arbitration, and it would be fair to say that the scope of your expert evidence has quite significantly changed between your first and your third. Is that fair?
Well, I think it would have to. The first was, of course, on merits issues, and the third was on the relatively narrow questions of jurisdiction that I've been asked to assist on.
The first is a quantum report, effectively, yes?
Yes.
Your second report opined on 2 matters: whether the transactions are repurchase transactions and how common the type of master feeder structure in place above the transactions here is in practice. Yes?
Yes.
It's right that you don't have any specialist knowledge of commodity finance transactions, do you, Mr. Walk?
I only have the work that I've undertaken in connection with this project.
And it's right that you don't have any specific specialist knowledge of the structuring of Cayman Island fund structures either, do you?
That's correct.
And then in your third report, you address 3 things. Firstly, you respond to the evidence of Versant Partners that the transactions in this case are a form of commodity repo. Secondly, you opine on the relevance of accounting standards to the interpretation of the word control under the free trade agreement. And thirdly, you comment on Morocco's case that there's real doubt as to whether any of the allegedly owned commodities allegedly owned by Q1 and 2014 one still existed in August 2015. Is that right?
If I may object, Mr. President, the question implies that the response of Mr. Walk was to the notion of commodities repurchase transactions, whereas I don't believe it was specified as commodities repurchase transactions when it was first raised by respondent. And that's what he was responding to first. This is a subsequent point that has been made by respondent, that in addition to there being securities, repurchase transactions involving securities, there are also commodities repurchase transactions.
So you never said that this was a securities repo, never.
Well, I'm not saying he said it was a securities repo, but it was a repurchase transaction. My understanding was not that it was specifically identified as a commodities repurchase transactions. So that's my objection.
Yes, 1 second. I'm slightly lost now about the objection, but I think we were, in order not to lose time, Mr. Ordway, sure. I think Mr. Walk has a lot of experience, and if there is any catch in one of the questions, or if he's being misled, I'm sure that he can pick that up quite easily and will defend himself. So I mean, in the interest of time, if we can let the cross-examination go, I would be appreciated.
I agree, Mr. President.
Thank you.
For the tribunal's note and for the transcript, Mr. Walk's third report, paragraph 3, he says, in terms, he's been asked to comment on the report of Versant Partners on the characterization of the transaction structure employed in the commodity transactions claims entered into as clearly typical of commodity repurchase transactions. That's the point. So that's the reference. We move on.
Exactly. Let's move on and let's get the expertise of Mr. Walk out, which is what we are interested in.
Mr. Walk,
yes, sir.
A refinery, and the hint is in the name, refines crude hydrocarbons into end products. Yes?
Well, it refines crude and potentially other feedstocks into refined products that might be end products, or they might be intermediate products that then become feedstocks for some later refining process.
Yes. And there are a number of costs incurred by a refinery in the course of operating its refinery, aren't there?
Certainly.
And one of the most significant costs of running a refinery, or one of the costs of running a refinery, is the raw product that you are then refining. Yes?
Yes.
And in the case of Samir, and tell me if you don't know this, that product is primarily crude oil. You aware of that or not?
I think it's probably a majority crude oil. I would not want the word primarily to be used to exclude other feedstock hydrocarbon products that Samir was acquiring and that Carlisle was acquiring.
That's very fair. I'm not suggesting that. What you do know though that Samir is one of those refineries that doesn't have its own proprietary supply of crude oil, unlike say what some of the Bahrain refineries. Do you know that?
To the best of my knowledge, that's correct.
So when it's whatever the product is it's getting in, whether it's crude or an intermediate product or whatever, it has to pay for that in order to run its day-to-day refining operations, yes?
I would think so.
And it will have to have some stock in tank for the day-to-day operations, but it will also need to have lined up some cargoes to be in transit to keep constant production, yes?
It would need to have sufficient stock on hand and on the water or under contract to be able to maintain whatever its anticipated production schedule was.
And the money that it needs to have available for those purposes, the purposes of acquiring stock, that's part of what is referred to as working capital of the refinery, isn't it?
Yes.
And there are different mechanisms through which refineries like Samir can finance their working capital, aren't there?
Of course.
One option is, if the refinery is profitable and has good cash flows, it can use its own cash reserves to buy its inventory, yes?
If it is profitable and has sufficient cash flow, yes.
Another option is to obtain third-party financing for that inventory, yes?
Yes.
And one example of that might be a working capital loan, say.
You could have lending that would be involved, yes.
Yes. And if you have a working capital loan, that's quite often done by a bank, say, lending money to a refinery to acquire inventory, and usually that loan is then secured against the crude inventory of the refinery, sometimes also against the refined product. Yes?
I would think the bank would take whatever security it could get for its loan.
Yes.
It might differ from one bank to the next.
You can also have the refinery could pledge some of its assets to security, it could assign receivables under contracts, yes?
Yes.
Now, one of the alternatives to an outright loan arrangement is for a refinery to enter into a commodity repurchase structure, isn't it?
That would be one way you could do things, yes.
And we can see that if we look together at the exhibit RE27, just give me one moment. Now, if we look at that, this is a chapter from a book written by the law firm Sullivan and Worcester, which is a trade finance practice, and this is dealing especially with the financing of commodities, isn't it? Particularly oil and gas. Have you seen this before, Mr. Kwok?
I've seen the exhibit. I will take your word for the characterization of the law firm and what the book is about. I haven't seen the book.
You haven't got the book, okay. Now, can we go on to page 7 of this PDF, please? At section 4, we have alternative financing and payment structures. And the first alternative they mentioned there is a sale and repurchase called a commodities repurchase structure. You see that?
I see that.
And if we go over the page, they explain that there are that this structure has some particular advantages where the company concerned is highly leveraged. The seller effectively is highly leveraged. Do you see that?
I do.
And one of the risks in such a repo financing structure is that it might be recharacterized as a loan. And that's a risk that people in the market are very concerned about, isn't it?
I believe that's correct.
And Mr. Zueck gave some evidence about why that's the case, and there are other reasons given here as well. But that's why it's very important for these types of structure to put in place clear contractual structures and storage agreements to ensure that the transaction is characterized as a true sale rather than a loan. Does that accord with your understanding?
Yes, it does.
But there are different ways to structure a commodity repo financing, aren't there? Do you not agree with that?
I'm trying to make sure I understand your question.
Are there different ways in which you can structure a commodity repo, or is there only one way?
I would think you could use more than one method.
Well, let's look at what an expert in this, a finance partner in Reed Smith, who deals with this, says. That's RE28, please, if you can bring that up on the screen. And what we have here is, if we can go down a little bit, the title is Commodity Issues Arising in Commodity Inventory Finance. And then under the heading, if we go down to Market Trends in the middle of the page, if you look at read that paragraph to yourself, the last sentence of it says, where traditional secured loans backed by a pledge or of a warehouse receipt were once the financing tool of choice, increasingly wholesalers are looking to enter repurchase transactions or to repo the copper to banks willing to participate in these structures. You see that?
Yes, I do.
And this is talking in the context of the Asian copper trade in Shanghai. And what you see, and I think you referred to this in your slideshow, is the next sectional contract forms, which shows there's no industry standard form contract for a commodity repo, equating to the GIMRA. You see that?
Yes, I do.
And in the middle of the paragraph, there's this Reed Smith law partner explains that the transaction can involve either a firm commitment or or sometimes an option around the repurchase. Do you see that? These transactions may provide for a firm commitment of the bank to buy and then resell the commodity, or involve some optionality around the second sale leg. Do you see that?
Yes, I do.
And you don't have any basis to say that Mr. Brown, who writes this article, is wrong about that, do you?
No.
So the fact that a structure embeds an option in the second sale leg doesn't mean that it's not a commodity repo, does it?
Not necessarily, no.
Sorry, could you repeat that answer? I didn't hear it. This is
I said not necessarily, no.
Is that all right, Ms. Burden?
Yes, sorry to interrupt, yes.
Not a problem. Now, in the context of a refinery like Samir, the point of the commodity repurchase structure would be that the financing party buys and holds inventory, which reduces the working capital requirements of the refinery, yes?
Well, in the case of Samir, I don't doubt that Samir wanted to reduce its working capital requirement and obtain financing, but I don't think that referring to Carlyle as the financing party accords with my understanding of what Carlyle's interest in the transaction was, nor do I think it is consistent with what Mr. Zwick's testimony was this morning.
Well, we'll leave Mr. Ordway to make whatever submissions he wants about Mr. Zwick's testimony. Let's look together at RE29 shortly then, just to see if this helps you. This is a paper by Kimura, which is a London-based specialist in commodity finance. And at page 10, there's a discussion of commodity repo transactions. And you'll be familiar with this, this structure. It's explaining how it's an alternative to warehouse receipts, which we saw the Reed Smith partner saying as well. Apologies, that's a little bit further up the page. And then if we go down onto page 11, please. That's the warehouse financing point. And then we start with the repo transactions. A variation of warehouse finance is where a customer sells a commodity to the lender and simultaneously agrees to buy it back at a fixed or determinable future date for a prearranged price or against a determinable formula. The lender then has title, etc. Now, I'm not going to go through all of it because it's repetitive of what we already looked at. But if we look on page 11 at the structure chart, under the word purpose on the right-hand side, so repo transactions purpose, to enable a customer to temporarily sell stock for cash with a buyback agreement so as to improve cash flow without drawing on credit lines, a settlement risk only is required. And you'd agree with that, wouldn't you?
I think that would be one potential purpose. There could be others.
And the last bullet under the key issues point, lender has flexibility to structure via fixed terms or through call and put options. So Kimura seems to think that the lender in this structure has the flexibility to include options in a commodity repo. And as we discussed, you don't disagree with that, do you?
What I see there is the lender, as to use Kimura's term, having the flexibility to structure the transaction with a call and a put option, similar to what Mr. Taylor put in his slide. And that's what I think is different in the Carlisle-Samir transaction, because it does not have the call option.
That's quite right. But so you're saying that your understanding of this is that it is only where there is a call and put option that it's a commodity repurchase transaction. If there's only a put option for the lender, then it's no longer a commodity repurchase transaction. Is that your evidence?
Well, if there is only a put option, then there's no obligation to resell. And typically in a commodity repurchase arrangement, I would expect to have an obligation to resell, because otherwise, what's the reason for entering into it if you can't get your inventory when you need it?
Well, shall we go back to what Mr. Brown said in his paper? Is it your evidence that that's what he's saying? So they're all wrong. That Mr. Brown, the partner at Reed Smith, and Kimura, that they're wrong to say that you can include optionality in a commodity repurchase agreement, are they?
No, I don't think
they should have said you can only include a call option.
I think they worded things the way they chose to for whatever reasons they did. I think if you scroll down a little more on the Kimura document, if memory serves me correctly, there's a bit of narrative that might address that in the right here, where we say the recourse is usually to the commodity in the event the repo party fails to take up the goods. Usual mitigants will therefore protect the value of the commodity in its route to disposal. That to me is talking about the optionality piece. And so if you are using both a call and a put option, you have protected in this case, Carlisle through the put option, because it now has another route in the event Samir doesn't perform. You've also protected Samir by having a call option. That's not what we see in the Carlisle Samir transaction, though.
So let me just pick this apart. Your evidence is, if we scroll up the screen, what this should say in that fifth bullet under key issues, should that the lender has flexibility to structure via fixed terms or through put option. Oh, sorry, or through call option, you say. It's only if there's a call option that it's a commodities repurchase agreement. If there's a put option, it isn't. Is that right?
I'm not trying to make a distinction about specifically what elements are required to use the term commodity repurchase transaction. I'm trying to say that this transaction, a series of transactions that we have in front of us, suggests to me no obligation to resell to Samir. There may be an intent to resell, and in that regard, you might view it as a repurchase arrangement, but there is not a commitment, and as a result, Carlisle has exposure to the potential upside in the event you have something happen in the oil markets that causes a spike. Now look at what's happening in the LNG market in Asia right now, where prices have gone absolutely crazy, and you're seeing cargoes being diverted. We saw that happen a few years ago in the LNG market when Fukushima occurred. The same thing happens in oil from time to time, and traders want to have the flexibility to be able to take that product to market somewhere else, which is what Carlisle was trying to protect and maintaining its upside.
Well, I'm a little bit confused by the first part of that answer, because you say you're not trying to make a distinction about specifically what elements are required to use the term commodity repurchase transaction. But when I've read your reports, that's what I've entirely understood you to be doing. So perhaps we've been at cross purposes all along.
I'm simply saying I'm not trying to get caught up in the semantics of specifically what you call it. The way that I had read respondents' filings and its expert reports was that it was trying to make this a simpler repurchase obligation, which I don't think it is.
That's an interesting point, Mr. Walk, because you mention in all of your reports, and you mentioned in your opening presentation, the word you always put in is simple. Can you show me where in any of the respondents' filings we say it's a simple repurchase transaction? You show me that, or tell me where you've seen us say it.
That is my term.
Well, let's move on. I want to look now the structure put in place by Q1 2014 modern Samir. That was a form of short-term working capital financing through commodity repo transaction structure, wasn't it?
That may be your view of it. I don't believe that comports with Carlisle's view of things.
Well, is it your view of it, Mr. Walt?
No, it's not.
Right. Let's see if we can break it down. You agree with me that the parties entered into a number of transactions, each of which had a maturity of around 120 days, yes?
I would agree they entered into an overarching agreement that had a multi-year commitment, within which they entered into a series of transactions of shorter duration.
Well, let's pick up on the first point you mentioned. You told us you're not a lawyer. You can't testify, can you? It's not within your expertise whether there's a binding multi-year commitment, as you just said, or not. Can you?
I don't think it will be helpful, and this Mr. Walk really can help us. Whether the commitment was a 3-year commitment only for Carlyle or only for Samir, that has been discussed by the parties. It's a legal question. I really don't think, Mr. Harris, that Mr. Walk can help us with that.
The purpose of the transactions that we're concerned with was to provide working capital for Samir, wasn't it?
I think Mr. Zuick testified that the purpose of the transactions was to obtain exposure to the commodities market for Carlisle's investment clients. Samir's purpose may have been different from that, obviously was. Samir could probably not care less about Carlisle's investment clients. Samir is concerned with Samir.
I'm now moving to protected information for the transcript and video. So we can see Samir was facing significant financial difficulties in early 2015, as we just saw, yes?
Yes.
And they'd agreed with Vermilion, as it then was, a transaction to obtain some financing from their perspective. Now, what I want to look at next is the question of the inventories of oil. Now, in your third report, paragraph 26 of your third report, I don't know whether we can bring that up on the screen. It may not be required. It's on internal page 8. Paragraph 26, you explain your instructions, address respondents' assertion that possibly all Carlisle's commodities did not exist at the time of the alleged expropriation. And you give evidence challenging this, as we heard in your presentation. Can we first agree that you didn't go to Morocco and look at these tanks in August 2015, did you?
No, I did not.
So you have no direct personal knowledge of what was in any tanks in August 2015 at Samir's refinery, do you?
No, my knowledge of what is in the tanks comes from the tank reports that were stamped by the inspectorate.
And you don't have any particular specialist expertise which enables you to give the tribunal any more information than it can get itself from reading the tank reports, do you?
Probably no specialist information that would help them to understand the tank reports. What I have done is categorize things to compare to the commodities products that Carlisle had purchased or swapped for. So hopefully that's of some help to the tribunal.
You don't have any particular information, any particular expertise which would allow you to judge whether, for certain, any of the products that were allegedly in Samir's tanks in August 2015 belonged to Carlisle, do you?
Can I ask the reporter to read that one back for me, please?
I will read it back to you. You
All
don't
right.
have any particular expertise which would allow you to judge whether, for certain, any of the products that were allegedly in Samir's tanks in August 2015 belonged to Carlisle, do you?
I would not be able to judge that with certainty.
And are you satisfied that you have undertaken reasonable research and investigation to reach the conclusions that you express in your report?
Yes, I am.
Can we look at that together? If we start at paragraph 27 of your third report, you say that Samir provided Carlisle with weekly tank reports of the tanks and that third-party inspectors were utilized to ensure the accuracy of the tank reports. Have you undertaken any due diligence in relation to how the weekly tank reports were prepared, Mr. Walk?
I have not.
Have you undertaken any investigation into the identity and independence of the third-party inspectors?
I have not undertaken research into their identity. I am aware that there were two different inspectorates that were used, one hired by Carlisle, one by Samir.
Can I take it that you didn't speak to either of those third-party inspectors when preparing your report?
I have not.
Now, paragraph 28, you refer to a Samir tank report of the 2nd of August 2015. And it's right to say that you haven't done any due diligence to go behind that report, have you?
I have taken the report at face value.
Yes. And you tell us in that paragraph that the tank report reported the following quantities of commodities purchased by Carlyle. Well, let's get that report up. It's RW073. And if we just scroll down into it and stop there for a second, it doesn't make any reference to any of the claimants in this document, does it?
No, it doesn't.
It's intended to show the total stocks allegedly held at Samir on the 2nd of August, isn't it?
I'm not sure that's correct. From my discussions with Mr. Zuick, my understanding was that the stock reports that Samir was sending to Carlisle were represented as being the products that were Carlisle's. But I should interject here that if I understand where you're leading with the questions, there may be a misunderstanding of what the language in my report meant that might be leading you down the wrong path. So if you
don't worry about me being led down the wrong path.
Okay.
I'm sure you'll correct me if I am. Do you accept that it's possible that some of the commodities mentioned in this report had been pledged or sold to other third parties?
I don't know whether that's possible or not.
Well, let's see if we can just assist with that. Can we put up C009 on the screen, please? This is Samir's statement to the Casablanca Commercial Court of its assets and liabilities in the context of the insolvency proceedings. The date is the 6th of October 2015. See that at the top. If we go on to the 6th page, to page 6, sorry, you'll see a full list of Samir's liabilities, its assets, and then short-term and long-term creditors. Do you see that?
Yes.
And you can see under short-term loans, the second name there is Vermilion in the amount of $393 million odd. Do you see that?
I see that.
And also under short-term loans, you can see a BCP loan of an amount of 761 million dirhams. Do you see that?
I do.
Could we go briefly into protected information very shortly, I'm afraid? Could the American parties be excluded? Thank you.
You're welcome.
Now, if you look further down here, you can see there's a heading long-term loans. Do you see that?
Yes.
And there are a whole range of quite high-value long-term loans there. And if we keep going down over the next page, do you see a reference to Glencore there?
I do.
And that's a well-known commodity trader, isn't it?
Yes, it is.
And it has a loan amount of $110 million odd outstanding. Do you see that?
Yes.
And if you go next one down, BP oil loan, $63 million. And again, you don't know, do you, whether BP oil or Glencore had security or owned any of the commodities in the tanks at the refinery, do you?
No, I don't.
Did you try to cross-check the tank stock report that you looked at with any other documents?
I compared the tank stock reports to the transaction confirmations between Samir and Carlyle. And that was the basis on which I said, the table that I set out in my report that you were referring to earlier, that this is what's on hand of the products that Carlisle had purchased. So Carlisle had purchased crude, fuel oil, gasoline, jet fuel, naphtha. And that's the comparison that I was making. See whether I was the same kinds of products that Carlisle had purchased.
Can we pull up the rejoinder on jurisdiction, paragraph 63 on the screen, please? Just read that paragraph to yourself. This is the claimant's rejoinder on jurisdiction. Now, you don't have to worry about the point that's being made by Mr. Zuak about belt and suspenders and not superseding the role of the transaction confirmations. But you can see there that Samir signed various custodian certificates showing how much oil it held in its tanks belonging to the various investment vehicles under the CSA. Yes? You aware of that?
I do recall seeing an occasional custodial certificate, yes.
Have you looked at those and compared those with your tank stock reports?
I think we did that at one point some time ago.
Well, let's perhaps do the exercise shortly together, because you don't set that out in your third report at least. If we can start with the table on page 10 of your expert report. Next page. This one. In the table there, you reproduce what you say is the inventory of oil held by Samir, commodity inventories at Samir on the 9th of August 2015. Yes?
This would be of the commodities that were the commodity types that Carlisle had purchased or swapped for. There are in the tanks then too.
There are other things in the tank reports than these. Yes? And I'm sorry, I'm not sure Ms. Burden picked up the answer to that. We didn't hear you, Mr. Walt. I think you said yes.
Why don't you start with the question again so I can make sure I've got that in my mind.
You were explaining that this would be commodities of the commodity types that Carlisle had purchased or swapped for, and I said yes, there were, because there are other things in the tank reports than these products. That's why you were making that point. Yes?
Correct.
No, I am now lost. Sorry. This is the total which existed of these various products in the tanks of Samir, or have you done any transformation of the numbers to get to this table?
The only thing that I have done is I have excluded any products that were not products that Carlisle had purchased or swapped for.
Okay, so the assumption is these are the products which Carlisle had been selling and or purchasing, sorry, right. And this is the total amounts which were in the tanks of Samir on August the 9th.
I don't know if this is the total amount of those products that were in Samir's tanks, or if this is the total amount of product that were in tanks that Samir had said, this is Carlisle's.
Okay, it is the totality of those which were in the reports which you received. These tank reports, This is the total amounts shown in the tank reports, and we have some doubts whether the tank reports only refer to the stock owned by Carlyle, or if it refers to the totality of the stocks which were there at Samir.
That's correct.
Thank you.
The numbers in my chart reflect the total volumes for each of these products that were set out in the tank reports that Samir sent to Carlisle.
Yeah.
Could you give me one moment, Mr. President? If we can look then at, sorry. I'm just seeing if I can shorten things a little. I've nearly finished in any event. So could we then look at, so in this table, as an example, you say in the first line that what you see in the tank report is 100,000 cubic meters of crude oil. Yes?
Correct.
Now, can we just get up, keep in mind the 100,000 cubic meters, 9th of August 2015. Can we turn to C0050, please? These are the custodian certificates issued by Samir. So this is supposed to show what they are holding for Carlisle entities for 2014-1, Q1, 2015-1 on the 10th of August 2015 under the CSA. Did you look at these custodian certificates?
I have seen custodian certificates, yes.
If we go on to page 23 of this PDF, so this is one day after the tank report you rely on. If we go on to the next page, apologies. Certificates addressed to 2014-1, and it's issued by the General Manager of Samir, Mr. Jamal Ba'amer. You see that?
Yes.
And it's under the MCTA and the confirmation. So it's a certificate to 2014-1 issued by the General Manager of Samir under the contractual framework. Do you agree?
Well, I don't know whether it's under the Master Commodity Transaction Agreement. I see he refers to it.
Okay. Well, let's work down a little bit. We go to paragraph 4B. Counterparties, representations, and warranties. So this is Samir's representation and warranties. All data contained in Schedule 1 is true, complete, and correct on the date it is delivered. Did you see that?
I do.
Let's go over the page. This is the schedule. If we keep going, you'll get to the schedule of the commodities. This is the custodian agreement for 2014-1. And it shows 725,777 cubic meters of crude oil, doesn't it?
That's what it says.
That's more than 7 times the amount of crude oil reported by Samir the previous day. Yes?
Well, your number you were looking at in the August 9th tank report, I think, was in, well, maybe it was cubic meters. I'm trying to remember if it was cubic meters.
It's in your report. It's 100,534 cubic meters.
Yeah, I said
in your report.
In metric tons, and I wanted to be sure we had it right.
Well, can you just pull it up? It's there, just to show him.
There we go. Thank
100,000 cubic meters. You see that?
Yes, you do.
So the answer to my question is yes, isn't it? It's more than 7 times the amount that's shown in this tank report.
Mr. Baum-Air is representing that there is substantially more crude oil than what the inspectorate report is showing.
And he's saying that is, he's being very specific, because this is go back to this is a specific custodian certificate to 2014-1. Yes?
Yes.
Sorry, we didn't hear that, Mr. Walk.
Yes.
And you're aware, aren't you, Mr. Walk, that Samir didn't get any deliveries of oil in August 2015? Yes?
None that I have seen.
So let's be clear, Mr. Walt. Samir was giving completely contradictory information in relation to its alleged holdings of crude oil on the 9th and 10th of August 2015, wasn't it?
That does appear to be the case, yes.
Those two documents are completely irreconcilable, aren't they?
On their face, yes. I don't know what the reconciliation would be.
You've not sought to reconcile them. We know that.
No, I have not.
And you're aware, aren't you, because I think you're instructed as an expert in those proceedings as well, that a judge in New York has recently found that Samir was continuously refining the commodities it received with the agreement of the claimants. You're aware of that, aren't you?
I am aware that there is a decision in New York that's on appeal that suggests that, yes.
Well, it doesn't suggest it, it finds it, doesn't it? The judge's conclusion, isn't it?
I don't recall specifically what the judge found.
And you're aware, aren't you, that the claimant's allegation in New York is that the employees of Samir lied to them and defrauded them. You aware of that?
I'm aware that's one of their allegations.
And yet you still felt confident in your expert report expressing the categorical view that Samir held products which were the property of Carlisle in early 2015, in early August 2015. Is that right?
I was comfortable in expressing the opinion that Samir held substantial inventories of the types of products that Carlisle had purchased, which leads me to believe that it is likely some portion of that oil was the oil Carlisle had purchased.
But as we've now seen, you can't have any confidence in that deduction at all, can you, Mr. Walt?
Well, you can have substantially more confidence in something that has been subjected to an independent third-party inspectorate than you can with something that's coming straight from the counterpart.
But as you told us, Mr. Walt, you haven't done any due diligence on those third-party inspectorates or spoken to them. So you have no idea whether it's any more reliable than what Samir says, do you?
I would think that it is more reliable than what you would get without the third-party oversight.
You don't even know whether the tank report that you rely on is showing only Carlisle or the total amount in the tanks, do you?
It's unclear to me which it is.
Yes. The final point I want to discuss with you very shortly is the accounting definition of control, which you and Vasant have expressed views on. Now, you know, don't you, that Vasant's position in their report is that from an accounting point of view, establishing whether an investment manager controls an investment requires a factual investigation of whether the investment manager is acting as a principal or an agent. Do you remember that?
I recall some discussion of that, yes.
And Versant conclude on their review of the material that from an accounting point of view, CCM would not control Q1, 2014-1 or 2015-1. Is that right?
I understand that to be Mr. Taylor's position, yes.
And you addressed that in your third report. And let's turn to that briefly, if we may. And it's at paragraph 18 and following. We'll bring it up on the screen for you. And you explain the purposes of the IFRS and FASB accounting rules. And you explain that the rules relating to control for consolidation of a company create a counterfactual whereby, through the prism of control, the legal reality of ownership is replaced by a counterfactual. Is that a fair description?
I don't recall using the prism of control. It's a rather interesting way to phrase things.
Well, is the essence of the point I made right? That point that I've just highlighted on the screen.
I would agree with the point that you've just highlighted on the screen.
And the point is that the rules allow for a party who does not necessarily own 100% of an asset to consolidate it in its accounts, nevertheless, to effectively treat it as its own. Is that right?
Well, that's one way in which you might get a different treatment from what you would have from a legal standpoint, but also it's the simple fact that you're taking companies that have their own distinct legal persona and you are treating them as if they were a single company. Now, there are good reasons to do that from an accounting standpoint, particularly if the companies are engaged in transactions with each other. So you don't double count sales. If you and I both have companies and they're owned by a common parent and you and I are selling stock back and forth to each other, you would consolidate it and eliminate those intercompany sales so that the parent doesn't report a gigantic amount of sales that are really just sales back and forth between our entities, such as the sleeving transactions were. So you would want to eliminate that and not count each one each time it happens and be reporting a very large amount of sales that never really involve third parties.
And the point, if I've understood you correctly, is that accountants are looking at the economic reality of the position.
Accountants are looking to try to reflect economic reality, but also they're looking to try to achieve a level of comparability across firms. So if you think about some of the other examples, whether we refer to a specific IFRS or not, you have instances in which you may be asked or required to account for things in a way that differs from what's really underlying the transaction, but you're doing so for a specific purpose of being able to allow an investor to compare your firm to a firm that has a different legal structure.
Yes, and you're effective.
Reflect economic reality.
You're comparing the different firms. You're comparing the different firms, trying to get a good proxy for economic reality. Yes.
Well, you're trading off. You're trying to get a proxy for economic reality in one area, but you may be losing your economic reality in another area.
Well, let's look at, you give an example at paragraph 24 and 25. You cite an example given in IFRS 10, which is cited in a report by Deloitte that you refer to. And if you look at that example, two investors form a joint venture in the pharmaceutical sector. One investor is responsible for research and development, and the other is responsible for manufacturing. And the last sentence in the quote explains that accounting rules require a decision as to which of the two investors, as a matter of fact, controls the business. And the way the accounting rules do that, where multiple people have control on a different part of the business, is to determine who directs the elements of the business that most significantly affect the investee's return. Yes?
That's what they
That's
said.
what it says. Now, that's not all of the quote in the Deloitte report, is it?
No.
Can we pull up RE22, please? And if we go to the first page, you can see it's the Deloitte report on the standard on consolidation issued by the International Accounting Standards Board. And there's a summary of what the report says in the box, the bottom line. Do you see that?
You do.
There are three elements of control: power over an investee, exposure of right or rights to variable returns, and the ability to use the power to affect the investee's return. Yes? You see that?
Well, if you could blow that up, I might be able to see it.
That's a fair point. Can you see it now?
Yes, I see that.
And that's what Vasant explained in their report, isn't it?
Yes.
There are these three distinct elements.
With financial reporting on a consolidated basis, yes.
Now let's go to page 2. And you'll see a subtitle called Elements of Control, Power. Sorry. Do you see that?
Yes.
The heading. So that is a section on one of the three criteria to establish control. If we go over to the next page, there's a box, there's observation. And there's where you took your quote from, yes? The two investors.
Yes.
And that's an example given of issues relating to power over a company, because it's under that heading. Yes, do you agree with that?
I'd have to back up on the document.
We'll scroll up.
We'll
scroll up.
Heading, but... Okay.
And you only included part of that quote in your report. You missed out the words at the end of the quote, in which begin in determining, which will now be highlighted. It's four lines up from the end. You left those out of your quote, didn't you? In your report.
Yes.
And there are also two additional factors in the next paragraph, E and F. The uncertainty of an effort required in a regulatory approval, and which investor controls the medical product once the development phase is successful. So really, what this passage of the IFRS rules is telling the reader is that to establish who controls a company, there is sometimes a complex factual inquiry required, especially where different individuals or entities might have different elements of control. Is that fair?
Again, for purposes of consolidation in financial statements, yes. And that could become more complicated if your two investors are audited by two different companies and they might both be trying to consolidate.
So the point in essence being made here is that from an accounting point of view, a determination of whether an investor controls an enterprise will involve factual situations that have to be evaluated on a case-by-case basis. Correct?
That's true, but my point was that the determination of standing under an FTA is a separate matter.
Well, let's come on to that. Paragraph 25 of your expert report, the next paragraph. Now, you say that you rather doubt that standing under the FTA can depend on whether, as a matter of fact, one investor or another controls the investment in a manner that would allow consolidation. You see that?
Yes.
And you conclude that the definition of control, and I quote you, is best left to those who are trained in principles of international law, not principles of accounting. You see that?
No, that is not what it says. When it refers to that task, it is referring to the immediately prior clause, which is evaluation of standing under an FTA.
Right. So let's just check that I've understood you correctly. I think I've understood your point to be that the methodology adopted by accountants to identify economically which entity controls an investment provides no assistance at all in interpreting the word control in the FTA in this case. Have I understood you correctly?
When you say no direction,
provides no assistance at all in interpreting the word control in the free trade agreement that we're concerned with in this case.
I would say it would provide very limited, if any, assistance.
But that's a legal question, isn't it, Mr. Walk? About the interpretation of the free trade agreement.
Well, that's my point. That accounting
not really something
intended to draw legal conclusions that would be helpful to the tribunal in determining standing under the FTA.
Your point is, Mr. Walk, that the methodology adopted by accountants is not of assistance in determining. You make a positive view that you express that the accounting definition of control, economic control, is of no assistance in interpreting the word in the free trade agreement. And what I'm putting to you is whether it provides assistance in interpreting that is a legal question for the tribunal, isn't it? Do you accept that?
Oh, I would accept that the tribunal can take in whatever evidence it thinks is probative of the issues on which it has to rule. Of course.
Thank you very much, Mr. Walker. I don't have any further questions for you.
Thank you, Mr. Harris.
Thank you. Thank you, Mr. Harris. So let us see if there are any redirect questions. Can we take off this document from the screen, please? And so I can see Mr. Ordway.
Yes. Actually,
can you wait 1 second, Mr. Ordway, so that we have a full screen and you can start from scratch? Because I think here we are.
Of course. No, I was going to say we do have some redirect questions, actually quite a few. Since we've been going 2 hours and I actually have to make a break for very practical reasons, I was wondering if we could take a slight break. Is that possible?
Very good. So it is now 21:25. Is a 10-minute break appropriate?
I think that would be fine. Thank you.
Okay, so we come back at 21:35. And if you can that gives you also some time to put together your redirect and make it more efficient, I'm sure.
I will do the best I can. Thank you, Mr. President.
Very good. We are back in 10 minutes. Excellent. So we resume the hearing and I give the floor to Mr. Ordway on behalf of claimant.
Thank you, Mr. President. Mr. Walk, you were asked some questions by Mr. Harris about the custodian certificates, and you were shown those certificates. Could we turn, please, to C50 and the last one of these certificates, which is the August certificate, please? Okay. Now, all right, that's fine. Now, do you have an understanding with regard to whether or not these were supposed to reflect what was held on a given day, or was it supposed to reflect what was pledged or something else? Do you have any understanding, Mr. Walk, in that regard?
I think it was just a verification of what Samir was holding for Carlisle at that point in time, or for a particular Carlisle investment vehicle.
Okay, well, could we turn to the last page? Is there anything about this that strikes you, this certificate, as the August certificate?
Is there anything that strikes me?
Well, the fact is, does the fact that it is unsigned have any effect on your conclusions with regard to its significance?
It suggests that it could be a draft. It could have been something that was or wasn't sent. I don't know what to make of that.
Do you have any reason to believe that the custodian certificates were supposed to be, or supposed to have primacy with regard to the amount of oil in the tanks one way or the other? What's your understanding in that regard?
I would suspect they would not have primacy because, as I said to Mr. Harris, in looking at things from an auditor's perspective, you look for third-party corroboration of evidence, and an inspectorate stamped report would be viewed as a higher priority of documentary support than something coming from one of the parties.
Okay. And you were asked about tank reports, and you provided information about tank reports in August. Did you look at tank reports for other points in time as well?
Yes, I've looked at all the tank reports we had.
Okay, and did those include tank reports for periods subsequent to that?
Yes.
Okay, could you, well, let's go to that. I think it's CZ 63 and CZ 64. And these were tank reports prepared by whom?
These were prepared or certified by Intertek, which is another inspectorate company. If memory serves me correctly, Intertek was the one that was hired by Carlyle to verify inventories at Samir.
And do these reports impact in any way your conclusions with regard to whether or not the oil that was in the tanks was or was not likely to be accurate with the reports that you looked at in August?
Well, since we don't see any additional deliveries after August, if they had shown an increase in quantities, I'd have some questions. They don't. They show that the quantities continue to decrease, but that there are still substantial quantities of oil.
So if it has any effect at all, would it be to sustain your conclusion or the other way around? How would it affect your conclusion?
It would provide some additional support for that conclusion.
Okay. In looking at, in making the determination that you did, you were asked by Mr. Harris whether what you relied on. Did you rely on anything other than the tank reports? For example, did you look at witness statements? Did you have conversations that contributed to your conclusion?
Well, I've had conversations with several of the Carlisle people, Mr. Zuick, Mr. Olivo, Mr. Subagia, and I've read their witness statements.
Okay, well, I'm not going to go into the witness statements of two of those individuals as per agreement with counsel for respondent. Did you by any chance look at the witness statement of anyone from Samir?
I believe Mr. Salem.
And then, let me just stop you there. I just wanted a yes or no.
Yes.
Okay, then that's a confidential matter. So if we could please.
Mr. President, before we do that, can I register an objection to the question? Mr. Walk doesn't mention anything about this as being anything he relies on in his expert report. The only things he refers to that he relies on are set out in his expert report, and it's not appropriate to introduce new evidence in redirect that's not mentioned in the expert report.
Well, just to be fair, the statement that I would like to show is not new evidence, and Mr. Walk is entitled to comment on it if he in fact reviewed it. Let me finish. Mr. Taylor indicated that he in fact relied on a whole slew of exhibits. And then when I asked him specifically, some of those exhibits he in fact had not looked at, and some of those he had. So I see no harm in my asking Mr. Walk about a document that he did in fact look at and that pertains to this topic, and whether or not he identified it specifically, because Mr. Taylor didn't identify specifically the management agreements that he relied on.
Okay,
so
he did in the footnotes.
Let us, gentlemen, let us show this document to Mr. Walk, and let's see what he makes out of it. And this requires that we exclude the United States?
Yes, it does. Now, you were, just to ask you another question about the whole issue of the oil in the tanks as of August 2015. You were asked about the tank reports and whether you have any specialist information that would help the tribunal or give them more information about the issue. But just as a simple matter, do you have any reason to doubt that the tank reports that you looked at and which you relied on in part were incorrect?
The only thing that would come to mind there would be the custodian certificate, the unsigned one that you just put up, to the extent that it differs from what's in the tank reports. And as I testified earlier, I would view something that had been independently verified and stamped as being the document that has appropriate value for it.
Very good. Now I'd like to put up C46, please. Now, you were asked some questions by Mr. Harris with respect to the transactions and how the payments were actually made. And I direct your, first of all, have you seen this document before?
I don't know, it's too small to see.
Okay, I'm sorry, we'll bring it out. Okay, this is a letter from Samir. Okay, and let's go to the date here. If we could look at the date actually, so that it's dated, as you'll see, June 27th, 2015. Okay, now let's go back to the other call out. Now, could you read that, please? VM party to directly pay to supplier any payment obligations due and owing from VM party to Samir pursuant to that certain master commodity transaction agreement. Any such payments by VM to supplier shall be deemed to satisfy such payment obligations, and Samir shall fully credit VM party in the amount of such payments. Now, you were asked questions about whether or not the payment was from Samir directly directing us to in other words, how does this affect your conclusions with respect to how those transactions were made and what directions were given, if any, if at all?
Well, I think this document would underscore what I told Mr. Harris, that I had seen evidence that Samir had directed Carlisle to make payments directly to the supplier on his behalf.
Very good, thank you. And then you were also asked about, and these are a number of questions again about the issue of whether this was a repurchase transaction, third-party financing. And at one point you said that in response to a question from Mr. Harris, that one way of doing a third-party financing for its inventory was to use a commodity repurchase transaction. And you answered yes, that it was one way. Okay, do you recall that?
More or less, yes.
Okay. But does that in any way alter your conclusion that, in your view, this was not a repurchase transaction as described by respondent in its papers?
No,
And why is that?
because of the element of put optionality that relieves Carlisle of any obligation to resell the products to Samir. As I understand the transaction, that was Carlisle's way of being able to have exposure to the upside potential for the oil, which is consistent with what Mr. Zwick testified to, that Carlisle's intent in entering into this transaction was investment, not financing.
Now, you were also asked by Mr. Harris whether the fact that a structure embeds an option in the second sale doesn't mean it is not a commodity repurchase transaction, and you said no. Does that alter your conclusion that it covers that as described by respondent, this is not a repurchase transaction?
No, what I have in mind in terms of repurchase transaction that has an option embedded in it would be what I described to Mr. Harris in response to his putting up the Chimera chart, which says that the transaction can be structured with call/put options. If it's got the call factor included in it, and so Samir now has a right to demand the resale of the oil and the performance obligation on the part of Carlisle, then it would be something that I would say more closely comes to a commodity repurchase transaction. This doesn't have that call option factor present. And so there is, as I read the documents, no obligation on Carlisle's part to resell to Samir. There is an ability for Samir to request Carlisle to exercise the put. So if Samir's inventories are getting low and it needs to take the oil in, it can ask, but there's no obligation for Carlisle to say yes.
Thank you, Mr. Walk. Now, you were also asked about the use of the term simple repurchase transaction in your report, and you said that simple was your word. Why did you use that word in response to the characterization of respondents' position?
It simply struck me that suggesting the transaction was somewhat more simple than it really is, that they didn't capture all the complexity. In particular, they didn't capture the derivatives aspects that are attached to the transactions.
And then, and I think this is my last question. You were asked about the reference in a Samir document to this, to the transaction being an inventory financing. And you said that this was Samir's view. It was not clear. Is that your view? Was it in fact an inventory financing?
I don't believe that that's how Carlisle viewed it at all, and it's not the way that I view it. I think Carlisle was actually trying to make a commodities investment that gave it protection on the downside price by having a put option to Samir, and protection on the upside by having the ability to not perform on the put, not exercise the put, and take the oil elsewhere.
I have no further questions.
Prices were going down.
Thank you, Mr. Walk.
Thank you, Mr. Ordway. Now let me see if there is any question from my colleagues, and Professor Grigeranaon, do you have any question for our expert?
Nothing on my side, Mr. Chairman.
And Mr. Wordsworth?
Just the one, which was Mr. Waltwood. You said that the structure of the Carlisle Samir transactions was not secured lending, and that it was not, nor was it accounted for that way. And I'm just wondering where should we be looking to see how it was accounted for, how the different transactions were accounted for? Which are the different sources of accounting documents we can go to the file and have a look at to see how it was accounted for?
You would, if you were looking for the documentary evidence from the companies, you would be looking to things like general ledgers, journal entries, financial statements. You would be.
What were you referring to specifically?
I was referring to information that I received from the people I interviewed that said they had accounted for these as investments in commodities, not as loans receivable. If I were looking at a balance sheet, for example, I would expect to see an investments line rather than a loans receivable line.
I see. I thought you were referring to specific accounts or sets of accounts that we could look at on the record. Is there anything that we can look at the record, on the record, to see how it was accounted for?
Not that I'm aware of.
Okay, thank you.
But following up on the question of my colleague, you were referring to, we would have to look at the accounting of the master fund. That's the first accounting system where these line items to which you have referred would appear.
Actually, I think it would be below that level, Mr. President. I think at the master fund level, you would see investments in whatever the downstream investment vehicles were. But that wouldn't tell you the character of their investments.
So I would have to look at the Q1 accounting books.
Yes.
Because one of the things I am struggling with is, Mr. Walk, is that apparently Q1 does not have financial statements, and that these are integrated, these are looked through, I think was the expression, in Celadon Commodities Ltd, in the master fund. So your point is Q1 has accounting, but it has no financial, has no balance sheet. I'm slightly lost. And to be very frank, I had never seen an animal which had, which was a look through, had not its own financial statements, and just was somehow consolidated. It's a sort of consolidation into Celadon Commodities, but not through a consolidation system, but through a look through. Could you, with your experience, shed some more light on this?
Let me try to do that. It's a difficult issue because, I mean, if you looked at the audit and accounting guide for investment companies, it's probably 1,000 pages long. I mean, it's just incredibly complex. Companies down at the bottom of the structure will have their own accounting records, but they won't necessarily publish financial statements. Their data will be rolled up into some other entity higher up that might account for things on a consolidation basis if they meet those requirements, or they might account for things in a different fashion. So say that the Q1, 2014 one, 2015 one don't have balance sheets, I'm not sure is correct. They probably maintain internal records. It may not be a balance sheet, it may be a ledger of what their investments are, another ledger of who their shareholders and interest holders are, and so forth. But they don't publish their own financial statements. I wish they did. It would make my work and yours much, much easier.
Thank you. Thank you. And so your professional opinion is that this transaction, if we were to look at the ledger of Q1, that this should be an investment line and not a loan line.
That's correct.
And that the put should appear in some, it must be disclosed in somewhere because you have a put and the put may have a value. So this will appear as a note or
I don't know if it would appear as a separate line or if it would appear as part of the investment, because you're going to measure the investments at fair value. We saw that in the Celadon Commodities financial statements where you saw things were measured at fair value.
So you would measure it at fair value using the put?
I would measure the value of the oil and the put probably together. I think the way they were designing the structure was intended to get what's termed hedge accounting, where you take the entire package, the underlying commodity, the option, the futures contract, and you value the entire package as a whole.
And when then there was, that would be on day one, no? When, say, one of the various confirmations is signed. But then a few days thereafter, you have the sleeve transaction. And we have been told that there is a time gap between the initial confirmation transaction and the sleeve transaction. Now, when you do the sleeve transaction, you would then again write it as a reduction of the investment line item.
The entity that is transferring title, Q1, I think,
yeah,
then remove that from its investment accounts. They would have what we term a credit entry, and the offsetting debit entry would be on the books of 2014-1 or 2015-1, where they would then record that investment.
And then the moment it is then transferred to State Street Bank, 2014-1 would be doing the opposite and would then reduce this investment line in its accounts and transfer it to State Street Bank.
I don't believe that's the case. I think that that transfer is done, it's a transfer of, I don't know what the legal term for it is, but you're transferring title to be held in trust. From an accounting standpoint, I don't believe you would make an entry removing it from 2014-1's books.
Okay.
I've been through that. It's been a number of years now, but I had a portfolio of student loan indentures that had some serious problems. And the trustee in that case, Bank of America, did not record the value of the investments on its books. The value stayed within the bond indenture and holding company structure that it had always been in.
I see. And I have just one aspect. You are quite certain, because here I had a different understanding, but that Samir does not have a call option. It can only ask, but it cannot force Carlyle to deliver.
Yes, I'm very certain of that. That's set out in the transaction documents. If Samir wishes to have Carlyle exercise the put, they can request that. Carlyle can then exercise the put, transfer title and be paid, or they can say, no, we're not going to, in which case they have to pay Samir what was termed a settlement differential, which is paying back the haircut Samir originally paid plus a premium.
So it's a disincentive. Your point is it's a disincentive, because I remember about this disincentive to not exercise the put. But your point is that if the value of oil, of crude, has gone up, this incentive may not be sufficient or may be offset by the increase in the oil of in the price of the crude.
If you had oil go from $40 to $45 a barrel, it's probably not enough of a financial incentive for Carlisle to pay the settlement differential and then arrange for a tanker to offload the crude and sell it elsewhere. If it went from $40 to $95 a barrel, I think you'd get a very different answer.
And very good. I had a last point. You insisted a lot on the derivative aspects of the transaction, that there were derivatives. Huh? Yeah. Can you be slightly more specific to where was Carlyle buying derivatives in the scope of this transaction?
It happens in a couple of places. A derivative, as I'm sure you know, is something that takes its value from the value of something else. So in a simple case, think about a put or a call option on a common stock. I trade puts and calls every week, and the put option or call option has a value that is linked to and derived from the underlying value of the stock, among other things. So in Carlisle's case, you have a put option that gives it the right to sell to Samir. That's derivative number one. You then have within the Carlyle portfolios hedging using short futures contracts. So they sell short in the futures market. That's another derivative. The futures price is determined in part based on the underlying price of the commodity.
But why is it required within this transaction that Carlyle sells these? Why is it necessary? I mean, they can do it in order to obtain a profit, but I don't see how the structure of the transaction requires that. You must explain to me. Is this to support the notes, or is it within the Celadon line of investment?
I think the put option to Samir is required based on the deal they struck with Samir.
I have no problem about that. The put option is, of course, a derivative. It is the other derivatives which, and we all agree that if there is a put and a call, then it becomes, I think everyone agrees it's a repo. And your point is there is no call. But you said, you put a lot of emphasis saying that there were other derivative aspects in the transaction. And I have not quite understood it.
That's for the protection of the notes entities and the note holders.
Okay.
Sorry, could you start that answer again, please? I'm sorry, I didn't hear it.
You are very far away now from you must speak up a little bit.
That's for the protection. I'm sorry, my throat's getting a little dry from talking so much. It's for the protection of the notes entities and the note holders.
Okay, so the package of securities to the note holders, to make it simple, included the put, the insurance, and also some derivatives.
Yeah, I believe that's correct.
Okay, so it was these 2014-1 and 2015-1 in order to get the Standard & Poor's investment rating, you had to have some derivatives to guarantee against the loss of value of the oil.
Yes, the short futures contract gives you another route to monetization of the commodity in the event Samir does not perform on the put option and you have to go into the market. You already have an established futures price that's consistent with the price the original transaction was based on. So you recover.
Okay. So this is belt and braces, that if I exercise the put option, if 2014 one does not exercise the put option and Samir does not comply, then you have to sell the oil on the market and you have already a short future which guarantees you the price at which you can sell.
Correct. So if the spot price is below the futures price, then you exercise under the futures contract. And if the spot price is above, you let the futures contract close out and sell to the market. Do whichever one makes you more money.
Very good. And so that is, when you were speaking about the derivative aspect, it was this additional security in the note package.
It was both the puts and the additional futures in the notes package, yes.
Very good. Is there any further question because of Mr. Wordsworth or my questions? Mr. Harris, do you have any follow-up question?
No, sir, thank you.
And Mr. Ordway?
I have no further follow-up questions. Thank you.
So, Mr. Walk, thank you very much for your help, and you are released from your obligations to the tribunal. Thank you.
Thank you, Mr. President.
And so with this, we are coming to the end of the day. We will then meet tomorrow at
9 a.m.
At 3 p.m. At 3 p.m. my time, and it's 2 p.m. in London, and whatever time it is in the United States, I will not even dare to say it, and but I would get it wrong. And we will then start tomorrow. After the housekeeping, we will give the United States the floor, and after that, we will have respondents closing and then claimants closings.
Very good.
And then we'll see how we go from there. We'll have to see. We'll have to see where we stand tomorrow. We will have to deliberate. We'll have to deliberate on. But I think it is too early now to say we want to hear the United States. We want to hear you. We want to hear your comments on how to continue with the procedure, and we will deliberate and we'll come back to you with instructions. So after claimant's rebuttal, there will be some time. You have to give us some time to deliberate, and we will come back to you and we will settle in agreement between all of us how we continue with the procedure.
Very good. Thank you, Mr. President.
Thank you. Thank you to everyone. Have a nice afternoon.